sign language. Oh. Thank you. It is 2:30. We are back for the second part of the day. We are starting at 2:30. We'd like to call the representative from Masfundise and Coastal Links, if they're joining us virtually or in person, to either one, switch on their cameras if they're online.
Afternoon. Just to confirm, we are joining online, and I am here from Masfundise, and Zakelen Kasima is here from Coastal Links.
Thank you so much. Okay. My voice. Thank you so much. In respect of Masfundise, just brief introduction, your full names as well as your role at Masfundise.
Yes, good afternoon. My name is Carmen Mandarino. I am the program manager and acting co-director of Masfundise.
Thank you so much. From Coastal Links.
Good afternoon. My name is Zakelen Kamisa. I'm a deputy chairperson of Coastal Links Eastern Cape.
Thank you so much. We'll start with the Ms. Maranio. Can you just, for the purpose of being sworn in as well, thank you so much. For the purpose of being sworn in or being affirmed, can you just kindly, your full names for the record?
My full name is Carmen Mandarino. The name of Mr. Zeki is Zakele Kamisa.
Ma'am, just your names? Your full
Carmen
names?
Mandarino.
Ma'am, would you be taking the prescribed oath or affirmation?
I will take the affirmation.
Do you consider the affirmation to be binding on your conscience?
Yes.
Do you affirm that the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, I affirm.
I affirm.
Thank you. Sir, on behalf of Coastal Links, once again, your full names for the record. So you just hold on for me. You're currently muted. Can you just unmute? Thank you.
My name is Zakelen Kamisa.
Thank you so much, Mr. Nkamisa. Will you be taking the oath or the affirmation?
I'll be taking the oath.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you say that the evidence you're about to give before the commission is the truth and nothing but the truth? If so, raise your right hand and say, so help me God.
So help me God.
Thank you so much. In terms of, I'm just going to remind you of the procedure. You have 20 minutes. Mr. Lindowuhle will remind you in the chat when you're left with 15 minutes, as well as when your time is up. The time starts now. Thank you, colleagues.
Thank you. Sorry, I'm just trying to share my presentation. And just give me a second. So yes, I mean, as I'm trying to see how to share the presentation, just to say, yes, this submission is made on behalf of Masfundise and Coastal Links, and what, for the sake of the time that we have, and in terms of the submission, what we're going to do is not to go through the entire submission, written submission made to you and at the end of February, but rather focus on what we think are some of the key issues that are coming across all the aspects of the submission made. I'm so sorry, I just need some assistance on the screen sharing, as I'm not familiar with how to share screens on Teams. Or if the screen could be shared by
Ms.
We
Maria,
have sent the presentation. I'm so sorry.
would you like us to share the presentation on your behalf? And then what you'll do is you'll guide our IT when you're moving to the next slide. Would that be?
Yes, that will be extremely helpful. Thank you.
Thank you. Can we assist in sharing their presentation? Linda, can we pause on the time so that they don't lose this time?
Apologies. I believe that I worked out how to do it, so please let me know if you can see my screen, then I can start.
We can see your screen. You may start.
Okay, fantastic. And apologies again for this. So as I said, we are making this submission as Masifundise and Costa Link South Africa. Both organizations have a long history in the small-scale fishery sector. We've been active in this sector for the past 20 years. And a lot of the work that has been carried out by Masifundise as an NGO in Costa Link South Africa as a fisher movement, the only fisher movement that has national footprint in South Africa. This work has informed, the work that we have done on the small-scale fishery policy and a number of issues, including customary rights, ocean economy. This is all informing our submission to the commissioners. In terms of our presentation, I will be sort of providing an overview of the issues that we want to raise, and then I will allow for the rest of the time to go to Zakele to really give a testimony coming from communities. Apologies, we also planned for our Costa Link's Western Cape member to join, but she is now facing electricity challenges, which is one of the issues that many fishers in the rural areas, which is the fishers constituency we work with, face. But in terms of our key messages that we want to share with the Commission, the first message is that in our view, the food crisis is not just a result of scarcity, it's also the consequence of exclusion and lack of historical redress, especially when we're looking at the rural fisheries context. Another key message for us is that fisheries and small-scale fishers should be better considered in the overall approach to food security policies and strategies. What we see and what is our key concern is that oftentimes we see fisheries being regulated just as an environmental concern and as a commodity, as opposed to food and an integral part of food system and food security and nutrition in the country. Indeed, we believe the fishers should be better recognized as food producers in local food system, as custodian of ecological knowledge, and as a central part of coastal and riparian communities' food security and nutrition. Yeah, when we're talking about riparian communities, what we mean is communities that live close to rivers, lakes, dams, and are depending on fresh water resources for the nutrition. And even though this is needed and we have fought for policy and recognition through policy for the past 20 years, many are still remaining excluded from marine resources, criminalized for their harvesting practices, and marginalized in the fisheries governance. My presentation is going to really look at the three main areas in which we feel that, or we see a failure to uphold the right to food to fishing communities, and what the challenges are in relation to this. The first area that I want to cover is around the historical inequalities and policy failures. Because indeed, and I think also from many of the questions that I have heard the commissioners ask, I think it's important that we situate the current situation that we are experiencing today in the broader historical overview and historical exclusion that continues to shape access for fishing communities. In fact, during the colonial and apartheid period, fisheries laws have largely dispossessed Black fishing communities. This has happened in different ways in different parts of our country. So, for example, on the east coast of South Africa, we see that many fishing communities have been forcibly removed from their land and their access to marine resources, and in fact were never allowed to develop the traditional fishing practices to, for example, being boat-based fisheries. They were simply denied access. In the West Coast, what we see is that many members of fishing communities were integrated, let's say, as workers into the value chains of large commercial fishing companies that were allocated rights. In fact, we can say that both during the apartheid and following during the after 1994, what we can see is that we have a large concentration when it comes to the commercial fishing sector and a lot of vertical integration. So in that case, for example, fishers were practicing small-scale fisheries, boat-based, but they were kind of forced, they only had the capacity to be integrated in the commercial sector. They were not recognized as such. And indeed, what we can say with certainty is up until today, we are still seeing the commercial fisheries being prioritized as opposed to traditional and small-scale fisheries. Also, what we can say is up until today, even though we have won legal recognition for customary fishing practices in the courts through the Gongose case, in practice, we can say with certainty that customary fishing rights are still not being recognized. Also, what I want to say here already, because it's something that I heard the commissioners and the team asking other colleagues before, I think it's important to understand that small-scale fisheries as a term, it's something that encompasses a number of different traditional, and overall fishing practices, going from artisanal fisheries to traditional and customary fishing practices, and also what one could call indigenous. This question is one that needs to be considered also from the perspective of what is the recognition that the small-scale fishery policy grants to different groups in this regard. But yes, I mean, in terms of the inequalities that we have witnessed, it has been a result of litigation and civic mobilization over the years that we actually have a small-scale fishery policy. This was a policy that was a result of an equality court case in 2005, which mandated the South African government to undertake a process to recognize small-scale fisheries as opposed or alongside the commercial and recreational fisheries and also subsistence fisheries. The recognition for small-scale fisheries was needed because the MLRA, the Marine River Resources Act, was only catering for subsistence fishing, which is very determined by a very small bag limits, and also there was a ban on selling on a subsistence fishing permit. The policy that we fought for and that we participated in developing, it's a very good progressive policy. It calls for collective community-based rights, food security and human rights to be at the center of the managing and the governance of small-scale fisheries, inclusion of women, ownership of small-scale fishing communities over the value chain, and recognition of customary and traditional fishing practices. While this was the objective of the policy, we have over time witnessed a myriad of challenges in the implementation. One thing that I do want to say for the Commission is that when we're looking at the small-scale fishery policy as written and gazetted in 2012, And then we look at the amendment of the Marine River Resources Act of 2014, and then the Small-Scale Fishery Policy Regulation of 2016. You will see in a comparison that a lot of what was promised in the policy, that was part of what was negotiated with fishers, it was completely lost in the regulations. And also I will point out here now that despite that submissions that we made at the time of regulation development, these were completely ignored. And so what we are seeing now is a lot of these issues are actually really related to how the regulations were imposed to the fishers. So, for example, when it comes to one of the key challenges that we face is that the process around the verification and sort of recognition of bona fide small-scale fishers, the establishment of fishing cooperatives, and now the system regulated to permits, are highly bureaucratic processes that have led to the exclusion of legitimate fishers, and today are still leading to the exclusion of fishers in terms of accessing rights, for example. Small-scale cooperatives were imposed to fishers in a top-down process and without adequate support. What do I mean by this is the fact that when the policy was developed, it was very clear that we needed to have collective community-based right-holding entities, but it was also clear that there couldn't be one-size-fits-all process or approach to this, because there is a lot of diversity in the communities that are engaging in small-scale fisheries, and one system wouldn't work for everyone. So what we are seeing now is that, for example, cooperatives have been imposed on customary fishing communities. Cooperatives have been imposed as a vehicle on communities that are largely looking at doing the small-scale fisheries for livelihood and food purposes, and so on and so forth. I mean, this is a kind of issues that we're seeing. Cooperatives are very highly demanding from a bureaucratic point of view. There is a mismatch between what the regulation says around the establishment of fishing cooperatives and versus what the Cooperative Act says. And indeed, then when it comes to the management of cooperatives through the CIPC, we are now seeing a number of challenges, including people entering the CIPC online system and changing information about the cooperatives without actually, consulting with the rest of the cooperatives. So we are now seeing, for example, a situation where there is a board of trustees that was elected by an AGM. That is not the same names that it results on the permits or on the CIPC. And now the department is choosing not to give permits to such cooperatives because they don't have all the documentation in line. But fishers were never trained about using CIPC. They were never really told about these kind of challenges. And overall, the CIPC electronic system is highly demanding of fishers. Another issue that I want to raise here is the misaligned allocation in the basket of resources provided to small-scale fishers. Again, as I heard some of the commissioners asking questions about this. And I think that the first thing that needs to be said is that the policy was calling for a multi-species approach as opposed to the commercial fisheries in this country that are regulated on a single species approach. So what we were saying here is that small-scale fishers should be able access to everything that is around them when it comes to fisheries resources, because we don't fish commercially. We fish for livelihood purposes, and so traditionally we have been using everything that was around us. But what we're seeing is that the department is indeed making allocations in a way that is very much focused on commercially high-value species, even though these haven't been what traditionally was accessed by fishers, and they are also not allocating what indigenous traditional fishing species, people would have caught historically. I also want to highlight that we have an issue of a bias in the permit system. The permit system has not been renewed and reviewed as a result of the small-scale fishery policy implementation. In fact, fishers right now have a choice between applying for commercial species and commercial permits. There is a boat-based, requires a number of documentations, requires license keepers to be, identified as the ones that will be the fishing. And this means that for many of the fishing communities, especially on the East Coast, where indeed historically they were not allowed to develop these fisheries, they will need to rely on third party to catch the species. And what we're seeing, and I think some of the colleagues were earlier talking about this, is that basically fishing cooperatives are forced to go into into contracts with commercial entities that will maybe, at the best of ways, they would say, okay, we will fish you with your permits and give you 50% of the profit out of it. At worst, we have seen cases where fishers are given only 10% of the value of the permit. And this is because essentially, instead of having commercial permits, we should have small-scale fishery permits that are tailored on small-scale fisheries practices as opposed to, imposing a commercial approach. What we're also seeing is that the other type of permit that is available to fishers is a so-called on-consumption permit, which is essentially what the subsistence permit used to be back in the days. You have very limited bag limits, and importantly, on the on-consumption permit, you are not allowed to sell. That's what the permit says, but the department says, well, people can barter for money. The permit doesn't say that, and this again exposes fishers to criminalization. Then overall, I think that one of the issues that we have identified is that in the narrative coming out of the department, there is an incredible push for commercialization of small-scale fisheries as opposed to valuing them as livelihood and food-provided entities. We often hear the department talking to fishers about the fact that they are businesses, that cooperatives are business entities. This is a business, and yet they are not given the elements and the support to actually succeed as business. But more importantly, what we are concerned with here is that, again, instead of looking at fish as a source of food, livelihoods, and cultural meaning for communities, we are looking at a department that is only looking at fish as a commodity. And in terms of the department, is also an issue that we want to raise is the fact that the department continues to tell us that they lack capacity, that, due to budget cuts and austerity measures, they do not have enough capacity to actually, support the governance of small-scale fisheries across the coastline. And so here we have to ask ourselves why the department with limited capacity is choosing to have a policing approach to the small-scale fishery sector as opposed to an approach that is facilitating access. And indeed, one of the other issues that we see with the implementation is the lack of the promised small-scale fisheries preferential zones that were identified in the policy and the regulation. Another key issue that I want to raise for the Commission is the issue of the ocean economy and conservation pressures. Again, the ocean economy has been an important issue that has been coming to fishers since 2014. We are seeing more and more the impacts of that over time. With the Department of Environment, Forest and Fisheries and the Office of the President launching Operation Pakisa. And what we can say is that the expanding of the ocean economy is increasing the exclusion of fishers. Fishers are now competing with marine uses that include industrial fisheries, oil and gas, mining, aquaculture, coastal tourism, and marine protected areas, as well as shipping. Here, what I want to say is that again, what we're seeing is that fishers small-scale fisheries in particular, is completely neglected in all these policies, from Operation Pakisa to then the Ocean Economy Master Plan, and now Marine Special Planning. Marine Special Planning, as an example, what we can see is that as a basis for Marine Special Planning, the government was supposed to collect a database of resources and information about the value of this different sector. A 200 plus pages report was produced on the economies of the ocean, and yet out of that 200 pages, there was maybe 2 paragraphs on small-scale fisheries, even though small-scale fisheries represent the biggest constituency of ocean users. So when we're talking at these kind of policies that are saying we have to balance between economic interest, environment, and right to food, for example, what we're seeing is that even the information used are completely biased, and there hasn't been so far an attempt to actually collect a significant amount of information around small-scale fisheries that could then be brought into these policies. What this means for fishers is an impact on lack of access to traditional fishing grounds, permits restriction and enforcement, and displacement from coastal spaces. Yeah, again, I just want to say that this is not just coming from extractive sector, which are there, like oil and gas, mining, and aquaculture, but it's also done with conservation approaches. Fishers are essentially being pushed out of territories in a call for protection of the environment. Again, we are looking at an environment being protected without the people that live in it, and we can imagine what the results of that is in terms of right food, but also in the actual protection of the environment. Lastly, in terms of the broader themes, I want to highlight the issues of governance of the sector and also the issues around customary rights. So what I can say is that we are witnessing structural governance failures when it comes to tenure security for fishers, both on the water and on the land, because fishing rights are treated as permits that fishers need to apply for, and instead of recognized customary rights. And indeed, what we are seeing is that some fishers have gained access, but overall there is very little control the fishers have. We just coming out of the International on Agrarian Reform and Rural Development, in which South Africa also participated, and what is clear from that conference is that reliable food requires secure territorial rights across the land, coast, and oceans, and recognition of customary fishing rights. We are still living in a situation where inland fisheries in particular do not have anything that is fully recognizing them. We have a policy, but this policy hasn't been implemented, and there is no clarity on how fishing rights will be allocated to the sector. But then also what we're seeing is that the kind of approach that from the department is actually also really negating customary fishing rights. We have a lack of meaningful co-management. So co-management is prescribed in the small-scale fishery policy and regulation as the relationship between the department and right holders, fishers right holders, as primary co-decision makers when it comes to the management of the resources. But yet, we only see a first attempt on implementation of co-management starting 2025. But at the moment, there is very little evidence of how fishers are actually being included and participating in decision-making as a result of this. Overall, we're also seeing a limited participation in decision-making, not just at co-management level and local level, but also when it comes to scientific working group and management working group in the departments that are taking the decisions on all these different species and allocation. So again, yeah, we have to think that there is more than 20 fisheries and management working group, and fishers are not being included actively, but also they are not being facilitated in terms of, having a voice when it comes to fisheries, fishing decision, both from a scientific point of view, including the traditional knowledge, and from a participation, an actual participation point of view. Overall, we're also seeing an issue of silos in governance. There is a lack of inclusion of food security and nutrition policy strategies when it comes to small-scale fisheries. Fish is seen as a commodity, but I would go even further in saying that even within the Department of Environment, Forestry and Fisheries, we are seeing silos where the fisheries unit in the department will allocate fishing rights to communities that are adjacent, living close to a marine protected area, and then they cannot access the waters because there is a marine protected areas, and yet we don't manage to get the two parts, the department, ocean and coast, and fisheries, to sit around the table and ask what is the solution to this issue. So, you know, fishers have been allocated rights, but they cannot really realize. Why this matter to the right to food? Well, for fishing community, the right to food is dependent on resources and desires fishing rights, access to coastal and riparian territories and waters, recognition of traditional and customary knowledge, and support to local food system. So I'm gonna stop here just to now give an opportunity to Zakele to share from what I said, Zakele, and now, you know, talking to your experiences, but also on behalf of Coastal International level. You know, please go ahead and emphasize what you think is important.
Carmen, unfortunately, before you hand over to your colleague, you actually ran out of time. He actually took 26 minutes. So perhaps what I can ask is perhaps in his your engagement with the evidence leaders, he'll be able to provide that perspective. So I'm going to hand over to the evidence team to then start with their set of questions. Thank you.
Apologies for that. Thank you.
Thank you very much. Very interesting and important presentation. I like to find one sentence in a submission that sums up the core of the argument that the submission is making. And I think I've found it on page 2. And I'm quoting, "Despite post-apartheid commitments to inclusion and transformation and a progressive policy framework, many small-scale fishers remain excluded from decision-making processes, denied access to customary fishing grounds, and subjected to harassment and criminalization." I find that a very succinct statement of the challenge that small-scale fishers face. And just as an aside, we had that discussion earlier about the definition and the scope of what is meant by small-scale fishers, as opposed to traditional fishers or artisanal fishers or communal fishers. And I wonder if you could just indulge the Commission by providing us with a short note, one-pager, just setting out these different terms which are in the area, because you said that small-scale fishers encompasses traditional, and it's a policy term. Maybe you can just explain the difference between those different categories or terms for us, if that's okay. What I liked about your definition is that you include, in looking at traditional fisher people or small-scale fishers, you include those who directly harvest resources, as well as those engaged in associated value chain activities, such as net making, boat building, processing, trading, local distribution of fish. And I think this might explain the difference that we see in the number that you use, your estimate of 80,000 people who depend on small-scale fisheries, versus the estimate we were given earlier by the Green Connection of 28,000 people, which is their number is the number of small-scale fishers relying on marine resources for food security. So does your number of 80,000 refer to just fishers and their families, or does it refer to all livelihoods generated by the small-scale fisheries value chain?
Thanks. So yes, we can definitely provide one page on definitions that could support the Commission in the understanding of the different types of small-scale fisheries. I do think it's important to say that in the law, as Marine River Resources Act, that small-scale fishery category encompasses all these different definitions. In terms of the estimates, indeed, I want to be clear that these are estimates. Unfortunately, we haven't had, or we don't have the capacity as a small NGO to actually carry out a full assessment on this. It should be, indeed part of what the government looks at doing. But our estimate includes also inland fishers. So we are talking about this category of people fishing in fresh waters that hasn't been yet even recognized or provided access to fishing rights. And then, yes, we are talking about every people that are involved in the fisheries value chains. I think that if we were looking at who actually benefits from fish as a source of nutrition and harvested by small-scale fishers across the coastline and inland, we will be looking at much higher numbers in terms of access to food through fisheries.
Okay, thank you. I was looking for the word union or unionization throughout the submission, and I didn't find it. And I was just wondering, are any of these categories of workers within the food value, the fish value chain, are they unionized? And if not, why not? Is it because they're mostly self-employed or family businesses? And would you suggest that trade union representation might be useful or important for advancing decent livelihoods and good working conditions in this fisheries value chain?
Yes, thanks. That's a very important question. I do think that there is some fish workers and also people working in the value chain within corporate and commercial fisheries that are unionized. I won't try to say which union, but I think under the big umbrella of COSATU there is food workers organized that are also working with fish workers in particular. When it comes to the small-scale fishing sector, one of the attributes that the sector has been having over time and for decades, it's the informal nature. So because small-scale fishers were not recognized, they have largely operating informally. And indeed, in community-based or other forms of associations that are not necessarily kind of your traditional commercial entities. So in that sense, I don't know if unionize is the right word here in terms of how the sector should be organizing itself. But one thing that is for sure is that indeed levels of representation from small-scale fisheries cooperatives, but also more broadly from the sector, having noted that the small-scale fisheries cooperatives implementation has excluded many fishers, should be welcome. And that's where I think that there is a role for fishers organizations, community-based organization to play.
Thank you. In trying to understand the underlying causes of the problems facing small-scale fishing communities, I identified 3 in your submission. The first would be that the policies, specifically small-scale fisheries policy of 2012 and the inland fisheries policy of 2022, are inadequate. But I'm not sure that's true because you actually applaud the policies as being quite progressive. The second would be weak implementation by the Department of Fisheries of these policies. But it could also be harsh implementation with respect to, for example, the permit and allocation system. The third explanation could be increasing dominance and market concentration of large-scale commercial fishing, which overrides the interests and rights of small-scale fishers. And the fourth one could be some combination or all of the above. Would you care to comment?
Yes, I think that it's important to say that the fight for the small-scale fishery policy was led by a need for recognition, a need for inclusion, and a need for historical redress. The policy itself is the result of negotiations that were undertaken as a result of the court order from the Quality Court on the Kenneth George case. And indeed, as a result of negotiation, we don't have a perfect policy, but we believe that we have a very decent policy that if it was to be followed in its principles and objectives and approaches, would have resulted in some sort of historical redress in our view. And so, indeed, where we see a lot of the issues coming in is with the implementation approach. As I said in my presentation, when we look at the 2012 policy as written versus the regulations that were then implemented in 2016, there is a staggering difference in terms of the how those principles will be implemented. Indeed, I think that part of, you are quite correct in identifying also the role of the commercial sector and market concentration as a challenge. I think the previous speakers have spoken about how even when the minister tried to allocate some commercial high-value species to the small-scale fishery sector, there was immediate reaction from squid, for example, in terms of challenging this decision, taking the government to court. This is not the first time that we're seeing this. We have seen commercial fisheries taking government to court around allocation on traditional line fish, on West Coast rock lobsters, and we continue to see that there is an effort and a compliance, I would say, from the department side to prioritize commercial fisheries, and indeed even trying to include small-scale fishery into a gateway for commercial fisheries as well. And this is a major concern that we have. Yes, thanks.
Okay. Then I was struck by your discussion about the blue economy initiatives and ecotourism, in the sense that you weren't as positive about these initiatives as I thought you might be from the point of view of small-scale fishing communities. And I'm wondering, looking for positives, are there any possibilities for small-scale fishers to benefit from these initiatives, from blue economy and ecotourism?
Well, our view on this issue is that the blue economy is being presented as a triple win economic policy that will look at creating economic growth, improving the economy, and also giving livelihoods and jobs to coastal communities. What we are seeing is that in practice, these blue economy policies are having the same approach that has caused exclusion of fishing communities, that has caused climate change, that continues to ravage our resources. It's the same system. So when we are seeing a policy that says we will do some oil and gas exploration here, and then next door we will put a marine protected area that will benefit ecotourism. This might sound fine, but what we are seeing is that there is no fishers to be found either on the oil and gas or the ecotourism. We are aware that we are living in a moment where, especially due to the 30 by 30 agenda promoted as part of the CBD, the Convention on Biodiversity, we are seeing a promotion of 30% conservation of oceans. But yet, what is not very clear to us is how are human rights going to be addressed in these conservation policies? How are we going to look at our small-scale fishers and traditional fishers, that includes traditional fishers, customary fishers, and so on and so forth? How are we actually going to allow for their assistance and survival, even while we are trying to protect the environment, especially considering that these are not those that are culprits of destroying the environment. So, I think that to be frank, we will have to see a very big change in approach to something called the ocean economy that promotes all these different activities to actually be able to say, yes, we can see some things. The practice, what we are seeing in reality is that, for example, when it comes to marine spatial planning on the West Coast, even though this is a very active fishing area, small-scale fisheries was basically not even considered. So, ideally, I'm not so sure, but the practice is one of exclusion.
And then my last question comes to your recommendations. Your written submission doesn't actually provide specific recommendations. You did have a slide on your presentation which does include recommendations, but they fall beyond the scope of this inquiry. For example, you recommend that the Human Rights Commission should investigate failures in the policy implementation. So I think maybe this is an opportunity for you to provide a supplementary document where you could be more precise and specific about what the Human Rights Commission should recommend to government, and I suppose specifically DFFE, in its report from this inquiry. So that's just a suggestion to you. I'm not expecting you to come up with new recommendations right now.
We will definitely do so.
Thank you.
All right, Thank you for the submission. I've noted that your submission are quite similar to the submissions in number of respect that we received from Mr. Flores and the is it Green Connection. So in that sense, some of the questions will be similar, but just to then request your perspective on those questions that have already been put to them. And for me, the first question, which is to really assess your positionality, we addressed in the morning that there is a difference between traditional fishes as well as indigenous fishes. And so just to establish who Coastal Links and Masifundise is representing as your constituency.
Yes. So Masifundise, well, it's an NGO, but Coastal Links, and I see that unfortunately Zakela is not in the room anymore, so I will reply on the behalf, but saying that Coastal Links, as constitutionally organized in the constitution, is representing small-scale fishers. Okay. Again, this goes back to what we said at the beginning of the submission, that when we're looking at small-scale fisheries, especially if we are looking at the entire coastline and some inland areas, we have a wide variety of fishing activities that will refer to small-scale fisheries, whether it's artisanal, whether it's customary fishers practicing the customary rights, and whether it is indeed what we call traditional fishers. I would say that the vast majority of Coastal Links members will regard themselves as traditional and customary rights fishers, notwithstanding that there is the changes in the definition as customary rights holders is well defined through both the Congoze case and other jurisprudence on this, whereas traditional refers to people that have traditionally been part of this type of livelihoods over time. But what I want to really emphasize is that the small-scale fishery policy does, and my understanding is that also the MLRA, nowhere we have a definition difference between small-scale, customary, okay, but I am not so sure what will constitute an indigenous fishers in terms of the policy and regulations as they are now.
Okay. It is important for us to understand who we are presenting, as I've indicated, because that is the submission that we had received. And the submission also indicated that and this is why the difference is important. The submission was that indigenous fishers are excluded from the current regulatory framework, but I hear you saying that from your understanding, the different categories of small fishes, which includes your traditional customary fishes as well as indigenous fishes, are included in the framework. Is that your understanding?
So I want to be very clear that our understanding based on the definition of the small-scale fishery policy is as such, that it should indeed include customary, traditional, indigenous. Okay. However, what I do want to emphasize again is that in the implementation of the policy, the department decided that the only way to be recognized as a small-scale fishers in the broader definition is to be part of small-scale fishing cooperatives. And as a result of that, many people are finding themselves out of the system, and they are finding themselves not being recognized in the customary rights. The policies, the amendment and the regulation says the word customary rights, but it doesn't say anything about processes that should be put in place by the department to actually document, recognize, and allow customary fishing rights to be implemented. So in other words, what I'm saying is, on paper, the actual solution to that recognition is there. In practice, the department has actually refused to engage on how to actually recognize the customary rights on the coastline.
Yes. All right. No, thank you then for the clarification. Again, like I said, I'm just asking for your perspective, and that from your perspective, the challenge is the actual implementation to actually ensure that all groupings are included. I've noted in your submissions that you have largely limited your submissions to the 2012 small fisheries policy, but you didn't make any submissions or even acknowledgement of the 2014 amendments to the MLRA, as well as its related regulations. So it's not clear from where I'm sitting whether the critique that you are making against the framework, is it to the act as it was before the amendment, or are you saying that even with the amendments that were made in 2014, the act is still deficient because it's not mentioned anywhere in your submissions?
Thank you. Indeed, the submission we refer to the small-scale fishery policy, and I believe that stand to be corrected the regulation. Our understanding of the issue is that the regulation is where a lot of the issues lie, and this is what we are critiquing. In terms of the 2014 amendment, we noted that the amendment does include customary small-scale fisheries and customary rights. But so, yeah, what we are seeing implemented are the regulations, and therefore that's what we are criticizing.
I think what will really assist us, if you can prepare a supplementary written submission where you specifically deal with any residual issues in the, the Principal Act as amended, as well as the specific regulations relating to small-scale fishes, like I said, because that is not included in your current submissions. Then the next issue, I think in that submission as well, because it's the question that we've been trying to grapple with the whole morning. When we are referring to bureaucratic barriers, for example, can you be more specific with reference to this is what the regulation is saying, and these are the kind of practical and bureaucratic barriers that it imposes? Because we've just received general submission. There are bureaucratic barriers, but there are no specific and with reference to the relevant regulations. If we can also then get those additional submissions from yourself. And then let me move on then. In your submissions, you do refer also to the, I hope I will do justice, is Gongqose Supreme Court case where there was the recognition of customary law fishing rights, and someone was, the conviction was vacated on the ground that the individual was exercising their customary law rights. But from your understanding then, how do these fishing rights differ from the rights provided for in the MLRA? Is it included in the MLRA, or are we talking about a separate set of rights to your understanding?
Thank you, and indeed I'm going to try to do my best with this topic, which it's also a legal topic, and I'm not a lawyer by training. But our understanding of the issue of customary, of what defines customary fishing rights, is that indeed there is a set of criteria that are defined in customary law, or that would actually sort of allow you to put fishing in a specific customary sort of box, let's say. Sorry for not the correct language here. But so when we are talking about customary rights, we're talking about a system of law that is practiced by a community, in our case a fishing community, that has existed and evolved over time, and that is part of a broader system that regulates and holds the land in community leadership and cultural rituals. So now, when we are looking at these specific characteristics that define customary rights, as the court did in the case of Gongose, we can say that not all the fishing communities will be meeting these characteristics. They are well defined and they are narrow in that sense. Because essentially communities will have to be able to show what management systems, collective management systems were already in place, and how were these regulated as part of the broader customary law. That's my understanding. And
maybe the last part of the question, your understanding, are these rights, are rights that fall outside the MLRA?
My understanding is that these rights do not fall outside of the MLRA, but again, part of the challenge that exists here is that nowhere in the MLRA or in connected regulations there is a spell out of what will be the process of recognizing these customary rights. In other words, the MLRA speaks about customary rights as amended, but it doesn't speak about how do we actually go about recognizing them.
Okay. No, thank you. Those are useful submissions. Now I'm going to move to the issue of the limited basket, which was also raised by previous presenters, and I tried to understand what the issues were. Maybe from your perspective, what is the issue with the current basket that is provided to small-scale fishers? And if you can at all also try to elucidate, because there were also submissions about you'll have an example of a basket of that contains 11 species, but then there'll be 2 that are activated. You can try to assist with that if you know anything about that, but just to get clarity on what the issue is with the basket.
Yes, I will do my best to make a submission on this, in saying that the issue with the basket, for a long and a short story, is that fishers have not been allowed to actually engage with the department on what they wish to see in their basket. Okay. As I said in my submission, part of what the idea was here is that fishers should be allowed to access whatever is adjacent to them, whatever they find in their land, in their waters. Instead, the approach that was taken by the department was to give a list to communities of all the possible species they could get, what are called, like there is a list as part of the regulation of what can be considered as part of the small-scale fishery basket. They were asked to choose out of what they wanted to see as part of the grant of rights permits or the letter of granting of rights. But then, in reality, what fishers have seen is that either they were provided with species that are not available in their waters, either because they are not near shore or they are not in that area. So, for example, if you are on the West Coast and you ask for sardines, you can only catch sardines in the East Coast, for example. And so that is one of the issues. And the second part of the issues is more related to the permit system used, where fishers could only apply for certain species only for commercial purposes and other species only for consumption purposes. So, for example, I'll use mussels as an example. Mussels, which are very prominent across the coastline, a key source of food, but also part of the livelihoods of many women, especially mussel harvesters. These are only available to fishers as on consumption species that they cannot sell on their permits, and not as a commercial species. Then you have other species, let's say traditional line fish, for example, that is only available to fishers as a commercial species that must be managed from the cooperative, ignoring that this is also a key aspect of food and nutrition and livelihoods at local level, where fishers take home, give to their neighbors, and they eat out of traditional line fish year round.
Okay. But the first part of your response, you spoke more about misalignment in terms of the allocation, which is a separate issue you've raised, but as a standalone issue that you had raised is the issue of limited basket. But your response related to misalignment, where you say you are given what is not available. But I wanted to just get clarity on the submission around limited basket, because I think, as I'm sure you'll appreciate, that fish is not an infinite resource. It is a finite resource, and so there needs to be then a balance between what may be desirable for a community and the need to also protect the environment, which is also another constitutional right, to ensure that the environment must be protected from future generations. But I got that the main issue is the lack of consultation, which perhaps even in that context, what will assist is if there was consultation on what is available, that can go a long way in addressing the concerns of the communities. Is that correct?
In part, indeed,
Okay.
it is an issue of consultation, but it's also an issue of species that have been traditionally used at local level actually not being made available through small-scale fisheries, even because they've been allocated to the commercial sector for long-term rights, or because they are now sort of regarded as new fisheries, even though these fisheries have been used for decades, if not centuries. I'm thinking, for example, of allocation, which is a mussel that is very common in the Western Cape. It's widely used, and now the department is starting a new fishery policy process just to include allocation. So also here I have to say that, as the minister said himself last week, the science that is used by the department is often not up to date, and indeed a lot of these management decisions seems not to be actually rooted in scientific biodiversity needs.
Okay, so in the areas where you worked, you were given the reasons by the department for the decisions, but you are saying they're lacking from an environmental perspective, those reasons that are given.
Yes, well, I mean, the minister himself, I have to say, for many years we're now trying to ask reasons every time fishers appeal. You know, we ask what is the scientific reason on why or a certain amount wasn't provided, so on and so forth. And we always, if we do get a response, will be environmental concerns. But then the minister himself last week admitted how the traditional line fish decisions wasn't based in reality, where he even said that when he looked at the science, it seemed like for certain species there was even more available, and yet a cut was made to small-scale fishes without any regard to that.
All right, thank you. We are going at a good pace. In your submissions, you mentioned the impact of mining on the rights of fishing communities, but I did not see reference to other environmental, concerns, such as what we see in the inlands. I'm not sure in the coast if it's also prevalent. Issues of sewer spillages that is going to water resources, and the impact this has on fishing communities. And also, I can only imagine that health concerns, not only to those fishers, but those who are consuming the fish, can you just speak more about that as well? Do you see it coming up in your work, the sewer spillages into our water resources?
Thanks for that question. Indeed, we did not include a lot on the submission on this point, because our submission is based on the evidence that we collected over time and where we have strong evidence. Having said that, I can say with confidence that many of the inland fishing communities, especially that we work with, and it's not as many as in the coastal sector, they have reported issues of pollutions related to sewage, but also other type of pollutions. So, for example, the issue of pollution from pesticides, I think is also something that should be very much considered, that we don't have or haven't had yet capacity to document. Spillage and sewage is an issue not just in the inland, but also in the coastal areas. And in one of the cases that we reference in our submission, looking at the droughts on the flooding in KZN, one of the things that emerged for us was that indeed, even though, beyond the flooding and before the flooding, there was already a huge issue of toxic chemicals being in the waters that actually, warrant a closure of beaches and a closure of the mussel harvesting.
Okay. I think we'll be benefited by, documentation of the stories that do exist of the impacts of other pollutants on fisheries, from sewer spillages as well as pesticides and other chemical toxins. I think that can then provide a whole picture of the context in which different fishing communities operate. Now I'll quickly move to the assertion about harassment, law enforcement measures being characterized as harassment. And is that also a fair characterization if an officer is enforcing a law to say that is harassment? And what is your, how do you propose then the challenge be addressed?
Yes, thanks for this question. I think it's a fair characterization to say that there is harassment when a law enforcement agency shoots at people and kills them or leave them disabled,
Yes.
and then accuses them of trespassing, doesn't provide any or trespassing in writing, and I'm talking about a specific case now as an example in Joseph Grebe, where indeed the fishers were shot at, and then when we look at what was the sort of the charge was trespassing in their own land that is recognized as such through land
Meaning
claim.
there's disproportionate use of force in the law enforcement action. Is that the harassment that you are complaining of?
Yes, that is disproportionate use of force, but also use of force where is not required. So again, what we are seeing is, and there is so many instances of this that I can talk to, especially in the Eastern Cape and KwaZulu-Natal. We have heard the fishers telling us so many times how law enforcement enters the premises of their house, checks in their fridges, whether they have fish or not. And now you might have fish from the day before, or and now the law enforcement is coming in and say, why are you having this fish? No warrants, no actual papers that actually says that they should be allowed to do so. I want to add for your information that indeed part of what we are asking now the department to do through a court case is to say, why we do not have guidelines for rangers and other environmental control officers who are engaging with fishers and using ports. We have this type of guidelines available for the police. Why are we not having them for rangers that are being given firearms and are also should be subjected to the same standards when it comes to the use of force? We have asked for these guidelines from the previous minister. We weren't given them, and now we have to take the government on judicial review on this question exactly for this reason.
All right. No, thank you. I am out of time. I think you've clarified that the harassment, you are talking about the unlawful actions of police officers, not necessarily that law enforcement per se constitute harassment.
Yes.
Okay.
I think that's
Thank you. I'm covered. The remaining question, you can make written submissions because I don't have time, so you will not be able to answer them. The balance, because we spoke a lot about the right to food, but we didn't really speak enough about Section 24, the right to environment. Where is the appropriate balance? How should that appropriate balance between these two competing rights be struck? And the last question that you can make written submissions on is the issue about the vessels, the slashing of the allocation of vessels from 565 to 77 vessels. Was there consultation? Were the reasons given for that decision, and the impact really, whether the slashing was limited to small-scale fisheries, or was there slashing of allocations for all fisheries? So those will be my last questions. Thank you so much, Commissioner.
Am I understanding correctly that we will make a written submission on these questions?
Yes, because of time, unless the Commissioner indulges you. I don't know, my time is up. Thanks.
Can I propose that you make written submissions, and I'll come to Commissioner Duli. Any questions from your side, Commissioner?
Thank you, Carmen, for your presentations. Could I get clarity? Are you a fisherwoman yourself?
No, I am the program manager at Masifundise, and our work is in support of fishing communities. I do come from a fishing town in Italy, but I'm not a fisherwoman.
I was given the impression that this is a joint submission between Masifundise and Coastal Links. And you were joined by a fisherman, Zakes or Zakele. Where is Zakes?
Good question. I am not sure. I believe he's been struggling with network, and so it is Rowena Europa who was supposed to be from Arniston. That's the challenges we face often.
Was there an attempt during this presentation? We've been engaged with yourselves for more than an hour. Was there an attempt when it was realized that Zakele has been disconnected to at least join another fisher person in your submission?
Commissioner, as I'm speaking to you, I haven't been able to look for another fisher to join us. Apologies, this is also a very busy week for us. We have many people traveling to Cape Town for a workshop that starts tomorrow, so I haven't been able to ask for someone else to join. Apologies for that.
Not a problem, Carmen. I'm asking this question mainly because a central aspect of your position and your presentation is about the meaningful participation of fisher people and fisher communities in these kinds of discussions, in decision-making platforms. So it becomes very important that while we advocate for meaningful participation, we don't also exclude the very same people that we are advocating for. It would have been very meaningful had it been recognized that Zakes has been disconnected and that attempts would have been made to at least join him so that he also has a part in the discussion to play as someone who is directly implicated in the issues that are being discussed. That is all from my side. It's not a question, it's just an observation. Thank you so much.
Thank you. May I respond to the observation? Because I want to say, Commissioner Antoni, I actually agree 100% with you. And this is part of what also we can see, how, for example, online consultations and a hearing or a meeting taking place in Johannesburg also means that rural fishing communities are often facing obstacles in participating, especially in many of the rural areas where network is so bad. So this is also what we're saying, that when consultations are done online, I do question of the extent of meaningfulness. I know that it's not the goal of the inquiry, but it's a challenge that we face consistently and that fishers face consistently, and very well noted.
Thank you, Chair. You spoke about harassment and the disproportionate use of force. What do you think should be the mechanism that would be used by the law enforcement officers when fishermen or fisherwomen do not observe the laws that are already existing?
Thank you, Commissioner. I think that we have laws and legislation in place that guide us in relation to this. Now, I'm not an expert on that aspect of the MLRA, but the LMRA has an entire section that speaks to fining, arrest, and what kind of measures should be in place when the provision of the MLRA are being contravened. One thing that I think that, again, I'm not going to say something controversial when I say that being shot at, killed, left paralyzed, having your home being searched for, and all the kind of human rights violation that we are seeing in our fishing communities are an excessive use of force. And this is where, again, we have made a request to the department to inform us on what are the guidelines in terms of use of force when it comes to these environmental monitoring officers of different nature, so that we can also be informed. There isn't such guidelines that are being provided to us when it comes to park rangers in particular, so those working for nature conservation agencies.
So, but you do appreciate that where there is a law, then what follows is that law enforcement officers would then be required to ensure that law is observed.
Absolutely, I don't disagree with that, but also we do think that there is laws that govern the extent of use of force that should be used by law enforcement when engaging with right holders.
Yes. So do you have perhaps a recommendation insofar as what is it that can be done to ensure from obviously the department that is relevant insofar as overseeing issues relating to fisheries? What do you have in mind as a recommendation? Maybe one can even say that if it goes as far as using police officers, that might be a bit extreme. And even worse, what we have currently is that now we've got the military that is being used in the communities insofar as now ensuring that crime does not prevail in certain areas. So do you perhaps have a recommendation that you have thought of that can be considered, which we can also maybe take forward?
Thanks, Commissioner. Yes, I think that our first recommendation is that training should be provided to law enforcement agents, whether it's the police or conservation officers, on the rights that small-scale fishers have and what they are exercising in terms of the law, because what we find is often that officers are not even aware of these rights. Then I think that another very practical suggestion here is that as we looking at co-management to be applied at local, regional, and national level, that enforcement authorities should be part of these co-management structures so that they can establish direct relationship with small-scale fishers and also good communication systems with them. And then, yes, overall, I think that the idea of having guidelines that actually are very clear on how law enforcement officers should be operating in this context will be highly beneficial both to fishers and to officers themselves.
Do you perhaps also know what are the likely what are the likely circumstances that would arise that would result in these conflicts? Do you perhaps have that information, or this would have been shared by Zakele, who unfortunately has had a problem with his network.
I think that Zakele would have done an excellent job to speak to his own reality in Port St. John's, where I was at a meeting there last year, where fishers were telling us how, yes, I mean, rangers are really not informed on what their rights are, and this lack of communication then results in harassment. And so, for example, one of the issues that I mentioned before is how fishers hold rights. And so, for example, they will go fish today and maybe, you know, they have fish in the fridge from the day before, and then, you know, an officer will come and say, and find them, or, you know, harass them in that case. But also, I think that another issue that is important to raise is indeed how the history of looking at conservation as something that needs to be militarized in this country. You know, whether it's a poaching strategy, anti-poaching strategy, and so on and so forth. That militarization of conservation is also leading to unfortunate situation where officers are taking actions before actually assessing what is happening. And I think this has been the case in many of the instances that we have witnessed over time.
Just one last question. You also said that the fishers are excluded from management and scientific working groups. But what would meaningful participation for fishers look like in practice? Do you perhaps have, you know, an idea of how you'd want that, you know, to be structured in order to ensure that all the voices are amplified, which will include all the categories, you know, whether we're talking men, women, but also persons with disabilities and, you know, really anyone else that wants to occupy that space. Thank you.
Thank you so much, Commissioner. Indeed, I think that one of short answer to that is to say that, again, the small-scale fishery policy of 2012, and then actually the regulations too, speak to a co-management system that should have a local co-management where fishers themselves, together with other categories in the communities, are part of a committee that is supposed to look at the management of the resources at local level. Then this is a regional and national. So if this system was to put in place, we believe that one needs to be bottom up, and that it will be inclusive and allow the voices of small-scale fishers to be much more included in decision-making and governance of the marine resources, which are now very much sort of only looked at in terms of scientific and economic aspects, and leaving out the social, cultural, and food value of the resources.
Thank you so much for the presentation. I think mine is in terms of I just want to look at your slides. I think it's in respect of your recommendations. This is slide number 8. You say ensure ocean economy and conservation policies do not undermine food sovereignty of fisher people. Could you elaborate on it? Because you know, when you started, you give us these 3 terminologies: small-scale fisheries, indigenous people, but then you also then refer to them as fisher people. I'm not sure if this is the term you use when you engage with the communities, or is this a term that has just found itself in the recommendations? But how do you balance that? How do you one, make this recommendation? My understanding is that by their very nature, indigenous people, when they do when they do fish, they consider conservation. They do not take more than what is required. So this recommendation, how do you then align it with the previous Mr. Sorese's presentation on how indigenous people engage with the ocean, but also the presentation by the Green Connection? How do you align this recommendation with other lived experiences as well as the presentations of the two other colleagues from the different organizations? That is just my question.
Thank you, Chairperson. I just want to say that when we're looking at the principle of food sovereignty, one of the key pillars of food sovereignty is to work with nature. So food sovereignty as a concept and a political vision that we put forward is inherently recognizing our small-scale food producers, whether they are indigenous people or, also other communities. They are thriving to protect the environment they depend on for their livelihoods and lives. This is very much different from top-down conservation policies that are being imposed, to communities and their territories from outside entities, and that are completely cutting the relationship that people have with the resources. This is our concern. We believe that a people-centered approach to conservation is possible, and especially to ocean conservation. But unfortunately, what we are seeing as things stand now in terms of the approach of the South African government to conservation, we are not seeing that being upheld. So I think that, in terms of the submission we made together with the submissions from previous speakers, there isn't a mismatch. There is a recognition, though, that we need to look at the conservation from a people-centered perspective that actually allows, especially rural communities, including indigenous fishers, customary fishers, and other communities, to be part of making decisions and managing those conservation efforts in line with also the right to food, the right to livelihood, and the right to environment.
Thank you so much. Just in terms of the requested supplementary submission, it is one, can you please expand on your recommendations? That is slide number 8. When you do expand on it, perhaps also just address the issue of referring to the community as fisher people, whether this term is an accepted term within the community. 2, the residual issues in respect of the Principal Act as well as the regulations. The documentary evidence of environmental challenges such as pesticides as well as sewage spillages, as well as the impact of the militarization of conservation. Perhaps what you can also do, because it does not appear in both the presentation as well as the oral submissions, the voices of the people of the people on the ground that you represent. Perhaps what we need to get is just that outstanding opportunity for Zex to make his voice heard, but in writing, on how he interacts with the right to food in terms of issues around fisheries. That supplementary submission needs to be made on or before the 6th of April 2026. You can use the email that you've made your submissions and copy Mr. Lindogutli in that. Thank you so much. You have an opportunity. You are now stepping down from the witness podium. You are able to then proceed with following the inquiry as a participant. Thank you so much, ma'am.
Thank you so much.
Colleagues, we are running behind time, extensively so. We are going to ask for the next representative of the South African People's Tribunal on Agrotoxins. Are they appearing in person or virtually? Okay, I see that there is a representative online. Can they just switch on their camera? Thank you so much. Just for the introductory purposes of this aspect, your full names as well as the role that you play at the South African People's Tribunal on Agrotoxins. Good afternoon, ma'am.
Good afternoon. Thank you very much. This presentation was originally supposed to be done by Danica Dube, who is the I'm sorry, I must be very nervous. Just give me a second. So, yes, I'm Hedy Swanby. I'm the coordinator for SAPTOA, and I'm standing in for Danica Dube, who is the General Secretary of the Commercial Steve Doran Agriculture and Allied Workers Union. He had a family emergency that he was called away to deal with, and asked me to stand in for him and sends his apologies.
Thank you so much. The apology is noted, as well as the role that you play at the organization, the South African People's Tribunal on Agrotoxins. Ma'am, just so that we are now stepping into the part where I swear you in, will once again your full names for the record as they appear on your ID document.
My name is Hedy Swanby.
Ma'am, will you be taking the prescribed oath or affirmation?
The affirmation.
Do you consider the affirmation to be binding on your conscience?
Yes, I do.
Do you affirm that the evidence you're about to give before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, I affirm.
I affirm.
Okay. Ma'am, 20 minutes for your presentation, and then Linda Gutle will advise you on the chat when you're left with 15 minutes, and then he will advise you once again when you run out of time. Thank you so much.
Should I share my screen, or are you able to put my presentation up?
If you're able to share your screen, it makes it easier because then you are in control of the slides.
I'm sorry, I'm not. Are you able to see my presentation yet?
We're able to see it. Thank you.
Okay, so the South African People's Tribunal on Agrotoxins would like to share their experiences on agrotoxins and how this poses a human rights crisis. And this presentation is in the category of the intersection between the right to food and related constitutional rights. So SAPTOA is really just a loose coalition of affected peoples and various stakeholders who have supported affected peoples to have their issues heard around being exposed to agrotoxins. And there's been many campaigns going on for many years, and there's a general feeling of powerlessness. And people felt that they weren't being heard. And the tribunal was mounted to give people a space to vent their struggles. And the reason we needed to have such a thing is because South Africa is highly industrialized, South African agriculture. We are the largest consumer of pesticides in Africa. Thousands of pesticides are registered, although we don't know very much about them, as there is no available database of registered pesticides in South Africa. From what we can work out from the information that we can get, about 195 highly hazardous pesticides are in use in South Africa, and about 60% of these are European Union. Pesticides are in the main regulated by the Fertilizer Farm and Feeds Act of 1947, which obviously it's incredibly old and is not fit for purpose in 2026. Through our tribunal, we learned that farm workers and dwellers and marginalized communities suffer the most, and there's a great feeling that no one is helping them deal with this huge problem. Even after the United Nations Special Rapporteur on Toxics and Human Rights, Dr. Marcus Orellana, came to the country in 2023 and published his findings on 2024, we didn't see any action to mitigate the problems that he raised in his report. And I think the most outstanding finding that he made is that environmental racism in South Africa, and it's the marginalized communities who bear the brunt of toxins and pollution. In fact, he found that the regulation is outdated and that it's not enforced. He was concerned about corporate capture and conflicts of interests in chemical registration. He spoke about the unethical practice of double standards, where countries who banned pesticides in their own countries are exporting those banned pesticides to other countries. He also spoke about the fact that we often hear that pesticides are necessary for food security, but this is kind of red herring. So our tribunal was heard on the 21st and the 22nd of March last year. And this is not a legal policy-making authority. It was a space for affected peoples and interested peoples to exercise their democratic right to participation and to feel heard. And we were extremely grateful to have eminent jurors hear the voices of affected peoples, as Judge Nabi Pillay, Commissioner Lila Ntuli, and public health expert Dr. Sophia Kirsten-Cairncross. And we had 2 days where affected peoples gave testimony, experts gave testimony, and further documentary evidence was submitted to our jurors. And the streamed, the live event that was streamed is available on our website. So in the 2 years that we were putting together our tribunal, we were dealing with various sectors, each holding their own piece of the puzzle on pesticides. And when we all came together for those 2 days, I think everyone was very shocked to see the extent of the public health crisis that is coalescing around agrotoxins. And we really want to shine a light on on the extent of human rights violations with the use of pesticides in our food production system. And we consistently hear that industrial agriculture is the only way to food security, and that banning pesticides will have devastating impacts on food security. And I think I've been watching the last few days of these inquiries, and maybe it's safe to say that industrial agriculture is not ensuring food security in South Africa, and that this notion needs to be a lot more carefully examined. We're very aware that South Africa is locked into an industrial agriculture system, and this is through policy, budget allocation, land ownership patterns, infrastructure, and food system value chains. And shifting out of industrial agriculture is deeply political, and it threatens more stakeholders in our food system. But it doesn't mean that it's the only means of food production. It just means that there is need for political will to begin the shift. Furthermore, there's about 2 million smallholders who also contribute to food security in ways that go largely unnoticed. And both commercial and smallholder sectors need transformation. And I'm talking about, for example, how smallholders are often advised by government to use hybrid seeds and pesticides. And if they're wanting to grow in agroecological ways or other ways, there's not very much support for them to go that way. So what we really learned at the tribunal is that the impacts of pesticides in our society largely go unnoticed, even though there is a massive public health and human rights crisis. And it's not just on farms and farm workers and farm dwellers, but spreading throughout our society. The tribunal demonstrated that pesticide harms, governance failures, corporate power, land ownership patterns, labor exploitation, and food security are deeply interlinked. And South Africa's food system cannot be transformed without addressing structural injustice. Some of the key tribunal findings included, as Dr. Orellana had already found previously, that farm workers, farm dwellers, and marginalized communities bear the greatest burden. Also, again, that the pesticide governance is horribly outdated, that legislation is fragmented across multiple departments. And when we looked at a lot of these, they really do give negligible protection, particularly to farm workers, but to society as a whole. Weak enforcement of laws on the farms, we found that it's pretty common for workers to be working without protective equipment, training, sanitation, medical monitoring. Very often farmers work for many years spraying, and then when they fall ill from the spray, they are evicted. And farm workers just say they feel like disposable people. And I think an important thing to point out in South Africa's regulatory system on pesticides is that the label is the law. So whatever is on the label is you're bound by law, and it's the end user's responsibility if anything goes wrong. And we really feel that this shields the industry from liability and places responsibility on end users who very often don't even have access to the label to even know what they're spraying or what's on the label. We also learned from the tribunal about severe health impacts, with evidence being presented that links pesticide exposure to respiratory illness, neurological damage, reproductive harms and cancers. And we heard quite a lot of evidence about children in agricultural communities who are widely exposed to pesticides. We also had expert inputs on the prevalence of toxic street pesticides. This is the illegal sales of highly hazardous chemicals that are used often in informal shops and in low resource communities where sanitation and waste management is not operating properly, and people are dealing with massive infestations of pests and are buying unlabeled, highly hazardous toxins to deal with the infestations. And many of us know about the tragic deaths of children who ate food contaminated by turbifos. So we see that these agrotoxins that are supposed to be used for our food production are also leaking into other aspects of our lives. Another very clear pattern that came out was corporate capture, regulatory capture, corporate impunity. And the pictures that you see here are of a disaster that happened at a chemical warehouse in KwaZulu-Natal in 2021. It was a warehouse owned by UPL, which was set alight during the riots, and thousands of tons of highly hazardous pesticides were stored here. And this toxic smoke burned for 11 days. You can see a picture here of a water body that is usually used for washing and irrigation. People lost their livelihoods. People are ill and will be ill for the rest of their lives, and have not had very much assistance to date. Some very troubling research, as I mentioned, was around children, and several long-term studies were presented with a cohort of over 1,000 children, and the kids were wearing bracelets for a month or so, and which was tracking their exposure to pesticides. And what we learned was that they're probably even more, their levels of exposure are even higher than the adults. They're playing in the water, they're playing in the soil. The spray actually very often comes right into their homes. People's homes are often right on the vineyards. It's not unusual to see washing hanging up as the tractor's going past, spraying, soaking those clothes with toxins. And these toxins are causing cognitive impairments, developmental problems, learning problems. And so this is another issue that's going largely unrecognized. So our feeling is that many of our rights are being undermined by the use of pesticides in our production system. Our right to life, our right to a healthy environment, safe work, everything to do with children, they are the most important. Their rights are prime. Our rights to health care and dignity and bodily integrity. And then because of the extreme secrecy around pesticide decision-making and what's happening, even just having access to know what pesticides are registered in our country, we feel that our right to information, fair decision-making and public participation is severely undermined. So agriculture based on toxins is not a choice, as we've always told. We really feel that it's time to stop turning a blind eye to the widespread impacts on human health, human rights, and environmental health. And that if we want to chart a new path, it's not just going to happen. There has to be a commitment in policy and budget to start new research and put in a mechanism to do this transformation. So we have, since 2010, we had the pesticide management policy came out in 2010, and that policy obliged us to start phasing out certain categories of highly hazardous pesticides. It's been 15 years. We don't see any concerted plan to see how we start phasing that out, because it's not just about replacing toxins with biopesticides. We actually really have to start thinking about a whole new system of agriculture. And we feel quite strongly that we shouldn't just replace the toxins with a biopesticide, but actually deal with the agrarian reform and the deeply inequitable nature of our agricultural sector. There are many obligations in our current legislative framework that require a transformation in agriculture towards agroecology or sustainable forms of agriculture. For example, the Climate Change Act, Preservation and Development of Agricultural Land Act, Agriculture and Agro-Processing Master Plan, and then our commitments under the Global Biodiversity Framework. In particular, Target 7 requires reducing pesticide risk by 50% and transforming agriculture and scaling biodiversity-friendly and agroecological practices up. Our recommendations to the Commission include the following. Set up an inquiry into pesticide exposure in South Africa. I think our tribunal just scratched the surface, and there's a lot of research that's needed around how this industry works in South Africa. We saw the need for some kind of independent chemicals and pesticide authority because of this fragmentation and lack of cohesion across departments. And then reform of Act 36 of 1947, replacing it with modern international best practice and climate change and biodiversity obligations. Definitely the need to increase transparency and accountability, including just the very simple need for a public national pesticide registry, which is actually required under Regulation 39 of the Act 36. Then we're very worried about a loophole that seems to be created for pesticides that have been banned. There's a process where companies can apply for derogations, and we would really like to see that investigated and scrapped, and strengthen the implementation of the international treaties that we are a part of. We'd like to see highly hazardous pesticides banned and all chemicals already banned elsewhere. And in fact, in the multi-stakeholder meeting held by the Department of Agriculture at the end of last year, this was a promise that was made, especially the issue of banning chemicals that are already banned elsewhere, because the science is already done. Strengthen health and environmental protections, including long-term health monitoring for exposed communities and independent environmental monitoring after chemical incidents. Then one of the big issues that came up was the issue of compensation. This is a very difficult issue. Corridor does not seem to fit for purpose, and the issues around claiming compensation are very difficult in terms of human burden, because farm workers or other communities often don't know what they've been exposed to, or if they go to the health services, they don't get a proper diagnosis. So really asking for some kind of no-fault compensation mechanism fund to be set up to deal with victims of pesticide exposure. And then lastly, to see enabling environment towards the transformation out of society, including research, policy, education, so that we can transform the food system and support agroecological, reduce pesticide dependency. I thank you for your attention and for the opportunity to present to you today.
Thank you so much. I'll hand over to our evidence leaders. We have 23 minutes. Thank you.
Thank you, I'll try to be quick. Good afternoon, Ms. Swanby. I'm Eileen. I'm going to ask you a few questions, and I'm going to try to be very brief, but I want to start with just perhaps getting a better understanding of the evidential footing of your submissions here at the Commission today. My understanding is that you are presenting findings drawn from the testimonies from the tribunal. And I just want to make sure that I understand you correctly. Is there a report from this tribunal with its recommendations yet available? I know that you were in Parliament as well on the, I think, 5, where Parliament also requested for the finalized recommendations. So I'm just checking whether those recommendations have been published, because I couldn't see them expressly in your submission. Perhaps I just missed it. Then secondly, your submissions are very rich in terms of testimonies from affected communities, and I do appreciate that. I'm just asking whether some of those individuals affected might be available for providing testimony to the Commission as well. That just assists us with primary evidence and understanding these submissions and all where these will be in fact reflected on the program as yet. So a question of understanding the substance of these submissions before I need to go into the content.
Yes, thank you very much. So the testimonies do come from our 2-day tribunal, and that was those testimonies were collected over a 2-year period, both from farm workers and to communities, and also public submitted their research. In terms of community members giving testimony, that's very powerful, and it's very unfortunate that Dale was not able to be with us today. He's a farm worker himself and heads up the union and has he would have had such rich experiences to share with you. There's no one on the program other than this presentation, but certainly we can bring farm workers and affected people to speak if that's required.
Thank you so much. That is very valuable. I think any level of primary witness statements would be very helpful to the Commission, perhaps even making available the statements that you have, if there are statements under oath, to the Commission on additional submission to the Commission, perhaps. And just back to my question in terms of the original recommendations that were referred to in May, is the recommendations available?
Recommendations are in a draft form at the moment, and we hope that we should share them with affected communities first and have their validation and have them understand what's in there before we publish them. And the intention is to publish the final recommendations in April.
Okay, no, that's clear. Thank you so much for that. Then from my side, in terms of going into the substance of your submission, there seems to be a very clear theme, and we have heard that theme throughout the submissions today as well. And the first contentious theme that has been put before the Commission today has been that there is, and I'm quoting the Commission to say that there is corporate capture. Now, as you would also derive from my earlier comment, is that it's very important for the Commission to be working with evidence and to assist the Commissioners and the panel who will be making determinations in respect of this inquiry with how do we derive to that conclusion. Now, from my side, perhaps with that as a context, can you explain to the Commission a little bit more and to the panel on how do we unpack this corporate capture? Who is capturing who in this submission? And perhaps if we can just start there.
Well, I mentioned that there is a publicly available register of pesticides that are registered in South Africa. If anyone wants to find out what pesticides are registered, you need to go through CropLife and pay for that register, and they can decide whether or not they can give it to you. We have had instances of members trying to access that register and having no luck. At the multi-stakeholder, we would have access to this register, and CropLife responded that this is their intellectual information, intellectual property. It's not available for public consumption. We did also have a letter from Minister Steenhuisen last year promising that by May last year such a register would be available, but it's still not. And I can't tell you how difficult it makes public oversight if you don't even know what is legally available and what is a highly hazardous pesticide, or we're just working in the dark. So that's one instance. I think Dr. Orellana, the special rapporteur, when he came, pointed out that he had found conflicts in terms of how pesticides are registered, and that industry members were involved in that process inappropriately. And that is reported in his findings in 2024. Yeah, those are two examples.
Okay, and is that then the reference to corporate capture that you are deriving from?
Yes.
Okay. I think, let me then go into my next question. You mentioned them in your submission, and you've just made mention of them expressly now as well. And perhaps just for the interest of the panel and the Commission, what is your understanding of the role currently of CropLife, and what is their relationship with their members, number one, and then government, number two?
I would say broadly, my understanding is that they're kind of an umbrella industry body, and they seem to have a lot of sway in government in terms of how committees are set up for decision making. Again, in the multi-stakeholder meeting last year, it was suggested that going forward with Act 36, a government committee would be set up to regulate pesticides, and that CropLife would not be part of that. And that was a highly contentious moment in the meeting where CropLife said that they didn't accept that proposal. So for us, being in that meeting, it seemed that that CropLife has really led the way. But I suppose that government has almost handed over regulation of pesticides to CropLife. this is how we see it.
Okay, thank you. That is helpful. Your understanding in that respect is very helpful. I just want to refer you to the Protocol for Pesticide Adverse Reaction Incident Reporting. If possible, are you able to provide the panel with a little bit more information on your understanding on what this Protocol for Pesticide Reaction actually entails?
I'm sorry, I would need to consult with experts in our coalition.
All right.
And come back to you on that. I can.
Okay, no problem. I think you did touch on it in your submission, as just to perhaps put it back to you, and maybe that would assist you, is that the protocol for one of the sections of this protocol indicates that the data and reports of adverse reaction incident reporting, which is then provided to CropLife, this data and reports shall not be made public by any parties unless agreed upon by both the Registrar of Act number 36 of 1947 and CropLife SA. So I want to put it to you, just to perhaps hear your comment on this. Is your understanding as well that data and reports in respect of adverse reaction incidences of pesticides are not publicly available, and that in fact it has to be agreed upon in terms of making this data public by CropLife in agreement with a government department?
My understanding is that the reporting mechanisms are highly underfunded. We did have testimony from the Poisons Information Center around reporting, and I think we've always been very confused to find that quite often on labels, instead of the number to report incidences is a number for CropLife rather than the national government helpline.
Thank you.
So,
yeah, that is perhaps where I am directing my question towards, because that is in fact the protocol for pesticide adverse reaction incident reporting, which I'm referring you to. And in that section, it indicates that CropLife SA will submit a general report to the registrar on a quarterly basis with specific report as mentioned under paragraph A, as and when required. And this is then the report that indicates that the government registrar and CropLife will have to decide whether the data is in fact then being made public. So that is if I can perhaps just have your final comment on your understanding as per my submission.
I was not aware of the protocol as you are putting it, so yeah, thank you for that.
Okay, no problem, we can move. So perhaps also in a supplementary submission, we understand that information is sometimes very sensitive as well. But as with every inquiry or commission of this nature, it does assist us when there are names provided to the commission and stakeholders and respondents who we can then invite to come and make their submissions as they are implicated during witness testimonies. So if you are able to provide the Commission with express interested stakeholders when you have made your allegation of capture, I do think that will assist the panel immensely when we then also put these submissions back to the responsible stakeholders. Then ma'am, can I request whether you made a reference to the UPL Cornubia incident, and it's reflected in your submissions in a very summary manner. May I request your indulgence just to provide the panel with a little bit more information on what the incident related to, and what your findings were in respect of the testimonies that were related to this incident.
So the incident was a chemical warehouse in Cornubia in KwaZulu-Natal, which was storing pesticides, many of which should have been notified under the Rotterdam Convention. Although there's some problems in implementing the Rotterdam Convention related to Act 36, but there was no notification of what was in that warehouse, and the local authorities also didn't know what was in that warehouse. And it was set alight during the riots that happened in KwaZulu-Natal in 2021. And as I said, it burned for 11 days with some of the worst pesticides imaginable, organophosphates, 2,4-D, all sorts of things. And unfortunately, because the local authorities didn't know what was in the warehouse, they weren't aware that they shouldn't use water to deal with fire. And when they used water, not only was the smoke a problem, but it spread these pesticides, spread the pesticides throughout the environment. And there were dead fish for 4 kilometers up the coast. The water and soil was polluted. There were dead animals in the nearby forests. And the testimonies that we heard were about the illnesses that people had, the loss of their livelihood. We heard from fisher folks, and we heard from locals who worked on the beach or who had small gardens. And also their deep frustration at the lack of and the slow pace of assistance in terms of clinics and assessing what the problems were. And that continues today.
Perhaps just a quick follow-up on there. Are you aware of any remedial steps that were taken by government, albeit a criminal prosecution, or civil issues that have resulted in redress?
Some of the members or some of the affected communities that testified are working on a class action suit, and this I think is going through the Southern Durban SDCEA, the Southern Durban Community Environment Alliance, and I think possibly groundwork, and that's ongoing. I don't know of any other remedial work that's been done, and a lot of the complaint was around how communities were not involved in the decision-making process.
Okay.
And kind of kept in the dark, yeah.
No problem. I have been given my Oscar music in the background that I must wrap up. Perhaps just 2 questions for a future submission as well. Just your understanding on whether the act that you keep on referring to from 1946, is it still fit for purpose? And also, what is your understanding about the incentives of having banned substances in other countries but still allowing those substances in South Africa? So if you can wrap that answer up in a minute, I would be very appreciative. Otherwise, we would really welcome your views on those as well in a subsequent submission. Thanks, Commissioners.
Sorry, can I just get from you again? You asked about Act 36 and its fit for purpose, and there was a second question.
It's perfect, yeah. Whether it's still fit for purpose, as well as the banned substances, and why one would still have those being actively made use of in South Africa, whereas other countries have already banned them.
Thank you.
Are you going to answer now or provide a
Oh, should I
answer?
respond to that now? Oh, sorry. Okay, yes, sorry. So yes, Act 36 is basically at the moment almost just a rubber stamp process where as long as you tick all the right boxes, then your pesticide will be registered. It's completely not fit for purpose or based on current knowledge and science. And in terms of banned substances, what we've been told is that just because something is banned in Europe doesn't mean we can ban it here, because we have different pests, we have different crops, different pests. And our feeling is that that is irrelevant because our bodies are the same, whether we're in Europe or here. And yeah, we need to make a plan.
Okay, I'm going to take over and ask three questions. Yes. The first one is that the pesticide management policy of 2010 committed South Africa to phasing out highly hazardous pesticides. And as you note, most have not yet been removed from the market. My understanding is that there was a commitment by the government to ban most of these by 2024, but then they seem to have backtracked. Can you update the Commission on where we are in this phasing out plan?
I think about 30 have been phased out so far. And as I said, what really upset us is that even while they're banning on the one hand, they created this loophole on the other for derogations. So there's an ongoing process of companies applying for even the ones that have already been banned.
Okay. Let me then move to the next question, which is how would you respond as SAPTOA to the assertion that banning the use of pesticides like Dormex and Turbofos would, to quote Minister Steenhuisen, have devastating impacts on food security? Is there any scientific evidence comparing crop yields using pesticides versus alternative approaches such as integrated pest management?
This is something that we've consistently asked for, the evidence that's behind these statements. We've also asked with our experts, particularly around turbifos. We did actually try and find data to show that turbifos would impact food security, and the experts we've consulted have not found anything to support such a claim. And when it comes to turbifos, it's already banned in all of SADC and in Europe without any consequences. So we really don't, it just seems to be rhetoric to us.
Okay. Then my last question actually follows on from that last point you just made. I'm sure that SAPTOA is aware of the EU Corporate Sustainability Due Diligence Directive, although it's not mentioned in your submission. And that directive mandates that large companies, European companies, have to identify and prevent or mitigate adverse human rights and environmental impacts of products that they produce and sell, not only in Europe, but throughout their supply chains globally, including in other countries. Now, this seems to me to be very significant because, in theory, European companies that are selling highly hazardous pesticides in South Africa could be prosecuted for the negative health impacts on farm workers and others in this country. What is the status of this directive, and are you campaigning on it?
We're just beginning to learn about it and starting to work with our partners on it, and we believe that it is a very significant opportunity. I'd also just like to put it in there that although it's very important what's happening in Europe, and it's we definitely will work on that. We must also remember that about 80% of our pesticides are coming from China, and also to keep our eye on that ball.
Thank you. Thank you, Commissioners.
Thank you.
Thank you so much. Due to time constraints, we are going to the panel, I think Commissioner Gunan and myself and Commissioner Dula may have questions. We'll then reduce them to writing, and then we will then request written replies regarding your submission. In terms of the supplementary submission, I think it's the tribunal report. You're stating that it's in draft format, but sometime in April it will be released. So once it has been finalized and released, can you share it with the Commission? Your statements or inputs regarding the protocol on the pesticide adverse reaction incident reporting protocol, just extend on that based on your interaction with the evidence leader, as well as the remedial action that you made reference to. You're stating that there is a class action that has been prepared, as well as the, I just want, oh yes, and the witness statements regarding the impact of pesticides in terms of their lives. In that, perhaps it must be done through affidavit, or alternatively, you can advise us if they're able to come before the Commission for that primary testimony through the oral submissions. This must be made to the Commission on or before the 6th of April 2026. Thank you so much, ma'am. You are duly released from the witness podium.
So, may I ask a question?
You may.
In terms of affected people's speaking at this inquiry, what is the timeline for that? Is that the 6th?
You can just identify people that are available and can provide testimony on or before the 6th. We will then notify you on the next steps by email.
Thank you very much.
Thank you. Colleagues, I know we're running out of time, and we have been advised we have until 5:30 with the sign language practitioners. I'm asking for a quick comfort break for 5 minutes, and we come back at 5 o'clock. And then we ask the African Center for Biodiversity to be ready immediately at 5 o'clock. Thank you.
CBD? No, last year, no. Oh, no, they've never invited us. Okay, so, another question, please, can we get the information? Is there any outstanding civil society mechanism? Just for civil society to get together and then make a submission together. It's on the interface between biodiversity and agriculture.
Thank you, colleagues. It's 5 o'clock. Can we start?
So what's going to happen? Just let's do yours.
Thank you so much.
Evidence before that. Yeah. Okay. Just do yours. And I'll be there to assist.
We're now swiftly moving to the African Center for Biodiversity. We will, just to the, as we noted the concerns from the department, we will come to the department and receive their written submissions, even if we do not have the language practitioners, so do not be worried by that. Colleagues, I see there are two representatives from the African Center for Biodiversity. Just for introduction purposes, your names as well as your role at the institution.
Hello, is this working? Yeah. I am Zakia Ismail. I am the Pesticide Research Coordinator at African Center for Biodiversity.
Good afternoon, Commissioners, ladies and gentlemen. My name is Miriam Mayat. I'm the Executive Director at the ACB. Thank you very much.
Thank you so much. Just so that I can, the process of swearing you in or affirming you, can you kindly just stand?
Okay.
Your full names for the record.
Zakia Ismail.
Are you going to be taking the prescribed oath or affirmation?
Affirmation.
Do you consider the affirmation to be binding on your conscience?
I do.
Do you affirm that the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, "So help me God." Oh, I affirm. Apologies.
I affirm.
It's been a long day.
Yeah, it's okay.
Thank you.
Yeah.
You may sit.
Zakia will be making the presentation, but I'm happy to also assist in any question and follow-ups you may have, and I'm happy to take the affirmation if you so require.
We so require. Full names for the record.
Maria Myatt.
Will you be taking the affirmation or oath?
Affirmation, please.
Do you find the affirmation to be binding on your conscience?
I do.
Do you affirm that the evidence you're about to give is the truth, nothing but the whole truth? If so, raise your right hand and say, I affirm.
I affirm. Thank you very much.
Ladies, 20 minutes, so by 17:24, you would have to have closed your presentation. I will then swiftly ask the evidence leaders without my direction to start asking their questions, and then we will come to the panelists.
Okay. I think they're still getting the presentation, so should I just get going though in the meantime? Okay, thank you so much for this opportunity. So the African Center for Biodiversity is a primarily research and advocacy organization, and our work is to promote food sovereignty and agroecology across Africa. And that's the framework from which we're doing the submission today, and which is the framework within which we do all our research and our work. So we want to enter this conversation by talking about a food system that is not neutral. It is one that is dominated by industrial agriculture, and from our perspective, it's shaped by corporate interests. And as it functions at present, it is marked by multiple systemic failures and fragmented governance. And the consequence of this is that there are constitutional rights that are violated daily. Rights around health, life, human dignity, food, information, and environment. So, in practical terms, we're going to start with looking at some evidence of failure through the lens of genetically modified crops in South Africa. So let me start with a victory for South Africa, and that for ACB as well. And that is the landmark Constitutional Court victory, which took about 10 years of challenge for the court to set aside the approval of Monsanto's genetically modified maize. So what this court findings were is systemic irregularities, is showing chronic rubber stamping, and a failure to conduct evidence-based assessments. And this speaks to a system that is broken, and it's confirmed by the courts. So, and then genetically modified crops are in an unholy alliance with glyphosate and also 2,4-D. So glyphosate is one of the pesticides that's widely used in our agricultural systems, specifically in maize. And the safety of glyphosate has recently come under question. It was always under question, but we have now, because of the glyphosate study that was used globally and potentially in South Africa that established its safety, the study has been retracted. It was retracted because it was found to have ghostwriting by Monsanto employees. The authors had undisclosed conflicts of interest, and also their reliance of their evidence was internal, unpublished studies. So from that, those irregularities have seeped into how South Africa has been regulating glyphosate. furthermore, there is in the US now litigation around the adverse effects of glyphosate. Yes, that's the one, thank you. Which shows, which has, so there's like 11 billion US dollars in settlement. The evidence, other independent scientific evidence shows carcinogenicity associated with glyphosate, endocrine disruption, gut microbiome destruction. Also concerning is that infants are at greater risk because of their immature organs and higher food consumption per body weight. Okay, thank you. So recently, ACB just took a sample of groceries, staples from our supermarkets and baby food, and we just submitted it to an accredited lab to establish what the glyphosate levels were in the foods. So we tested for glyphosate and EMPA, which is what degrades, what is found when glyphosate degrades. And this is relevant because EMPA has its own toxicological profile. However, there are no regulations around levels for EMPA. So what we found was that for example, Impala maize meal, the maximum residue level, and in snowflake flour, the MRLs were exceeded. The interesting thing, though, is that there are no published MRLs for wheat because it's not supposed to be used with wheat. Glyphosate is usually used with genetically modified maize. And so, which brings us into kind of a treadmill. There's GM crops that are designed specifically to withstand applications of specific pesticides, which is glyphosate in this year at the moment. And so there's this, and so we have GM crops, and then we have those pesticides that go with it. However, we get into this treadmill because then there's glyphosate resistance by weeds, which means either higher levels of glyphosate or new chemicals, like 2,4-D or glufosinate ammonium. And so we're trapped in a vicious cycle of dependency. For reference, about 85% of South African maize is genetically modified, and 100% of soy and cotton is genetically modified. So pesticides are kind of built into our food system at the get-go. And the results tell us that if it's used on the farm, there's no way to keep it off our plates and out of our bodies. Okay, so because of the treadmill, we also then have 2,4-D coming into the problem, into our food system. 2,4-D is half of what Agent Orange was used as, and it's associated with birth defects, cancers, death, and it was approved in South Africa in 2019, despite objections. There's new evidence that's coming out on 2,4-Ds acting as an immunosuppressant, and ACB has made 2 submissions to the registrar with no response, and 1 to the minister with no response. And so we're seeing the silence as maybe an absence of governance. At the middle of 2025, ACB published a compendium on pesticides, which was documenting the harms of pesticides. So this compendium represents over 100 studies with 20 years of evidence, and it looks at, it shows us that there are human health risks environmental risks, and okay, yes. And then also, it also highlights the structural inequalities that, because it shifts the burden. The compendium is represented by a number of highly hazardous pesticides. Many of those are banned in the EU. They manufactured there, they exported here, and they're used or sold legally in South Africa. So those standards do not protect us here in Africa or in South Africa. And what's been rejected in other parts of the world is still exported to us. And this highlights the structural inequality. Also highlighted other systemic regulatory failures due to, as you've heard, Act 36 of 1947, which is 78 years old, and it predates what's happening now. It's also our experience in the compendium shows that there's ineffective oversight. The industry themselves are not being monitored, and if they are, it's not openly evident to us that how they're being monitored. We also have found that there's low international compliance. And then the science policy interface, because everybody wants good evidence, scientific evidence, but the funding for independent research is so severely lacking that it really hampers the engagement with the health and safety risks that people are facing. So right now there's an over-reliance on industry's data, and as we've seen that there is a built-in conflict of interest. So looking at it broadly, there are a number of constitutional rights being violated. Environment, access to healthcare, safe healthcare and food, life, human dignity, access to information, and just administrative action. And you may have heard in the previous presentation by SEPTOA, the ACB faces similar struggles in terms of trying to establish what are the pesticides out there, how are they being regulated, what's being used, where are they being used, how much is being used. So what we're asking for is, first of all, to ban all highly hazardous pesticides in line with global standards, and particularly those banned in Europe that are in use here in South Africa currently. To ban herbicide-tolerant GM crops, and to prohibit any new applications, and then to phase out other hazardous pesticides and replace them with safer agroecological alternatives. This, of course, then requires replacing our Act 36 with a modern framework that centers public health, and we need a strengthening of oversight failures and to apply the precautionary principle. So we're not 100% sure something is safe, then to rather not allow it into our food systems, onto our plates, into our bodies. So in summary then, if we persist with GM crop concentration, with corporate control of our seed systems, with rural chemical exposure, especially to farm workers, people living around those areas, if farmers are dependent on proprietary seeds from international companies, and if we have, we then risk our own seed sovereignty. We risk farmers' autonomy. We risk agricultural biodiversity, which ACB has at present made submissions which were meant to be discussed tomorrow on that aspect. We risk the death of our indigenous seed practices, and that would no longer exist. And so that access to information or lack of access to information means regulators, for our experience is that regulators then ignore our submissions, and there goes our culturally appropriate diets. So this is the opportunity to decide where do our priorities lie and how do we move in a supported way from that concentration with so many risks towards food system that is both to a food system that is socially just and environmentally just for people of South Africa. Thank you.
Thank you so much.
Thank you very, very much for the presentation. I may just categorically state that this is not what has been submitted to us, the PowerPoint presentation, nor is it in the written documentation that I've received. So I would ask you if you would give us a copy on the email links, so that we can also maybe respond more specifically to the examples that you have used. But nevertheless, I think your submission emphasizes that the right to food is a constitutional mandate and that it's currently being undermined by systemic pressures in South Africa's food and farming systems. And then you gave these examples that we did not have time, we didn't see before. But I would like to focus on the submission where you said that in order to comply with the global biodiversity frameworks, South Africa must update our national biodiversity strategies and action plan. And this it requires inclusive whole of society participation. Yet our South African process lacks clear, accessible mechanisms. So what concrete measures are being taken to remedy this reported lack?
I think that there's some confusion because ACB made 3 submissions to the Commission. One was on, I think, the compendium, which was a very big piece of research that we undertook that looked at 100 peer-reviewed and other published information and documents recording the impacts of pesticides on human health and the environment. That was submission number 1. Submission number 2 was in relation to GM crops and associated herbicides. In that second submission, we discussed glyphosate, 2,4-D, and glufosinate ammonium. In this respect, we pointed out that we had asked the government to review the registration of 2,4-D. We made substantive submissions. No response. In terms of glufosinate ammonium, we highlighted the deficiencies in the legislation, which Heidi already discussed, where a pesticide is banned and then exceptions are created called derogations, and that we opposed that derogation. Until today, we have no response from the government. And in the course of interrogating the application by about 5 or 6 agrochemical companies, we discovered that they were all copy-paste. The same risk assessment was furnished for all of the applications of derogation. So we combined the issues around associated herbicides with GM crops together. That was number 2. A separate submission was made. That's why we were given 2 slots, today and tomorrow. But we were contacted and asked to come today to present 2. And that is why 2 of us are here today. We made a 3rd submission completely different, not to dealing with pesticides and GM crops. This was around the global biodiversity framework, the 3 goals and 23 targets, where we specifically dealt with the interface between biodiversity and agriculture, and the obligations of our government to provide a civil society mechanism for consultation, and then to address the drivers for biodiversity loss and decline, and how we discuss the role of industrial agriculture and land use change within that context, and then discussing the need for a just transition, dealing particularly with the climate change target, the target dealing with agroecology, and then linking it up also with target 7 of the GBF dealing with pesticides. But because of time constraints, we were asked to come today. But you ran short of time. So Zakia started first with presentation number 1, which was on associated herbicides. And she didn't discuss, we made a completely separate presentation on the GBF and the targets, but there's no time. So that's I think, I'm trying to clear up the confusion for the Commission, and I apologize if we didn't make that clear from the outset when we started the presentation.
Well, thank you, because that really clarified, but I have not interrogated your submission 1 and 2. I did not have access to it. But, so I wonder if I can, Eileen, if I can give a microphone to you.
Thank you so much. I'm going to also be very quick based on the same reasons that my fellow evidence leader has pronounced on. But I've found the reference to the SCA judgment and the Concord dismissal very helpful because of the question that I want to put to you, whether you would deem almost the same playbook being applicable with the Monsanto arguments, the lack of regulatory oversight, the reliance on almost one-sided evidence. You've made mention. You've made mention of a lack of funded research, independent funded research. Would you argue that if we superimpose the Monsanto arguments onto pesticides, that there are similarities that can carry across?
I think that there are similarities in the sense that, and we don't want to throw stones at the government because we understand that they're doing their best. We are not here to undermine administrative justice and decision making. We want to make that clear. We would like to have friendly and good relationships with our government. But we do understand the issue of lack of capacity, because I would imagine that the office of the registrar must be inundated with applications for registration, re-registration, extension of permits, because we deal, and we've dealt with GMOs and the registrar in decision making for the past 25 years. And if you look at the list of permits being granted, it's astronomical. So one could well imagine that there could be enormous capacity constraints. You're dealing with highly technical matters because in the realm of pesticides, it's all about chemistry. You need to know a great deal about these chemicals. It's not just the active ingredients, there's the co-ingredients, the adjuvants that go with it. In the field of GMOs, for example, it's a lot of molecular biology, and then you need to know quite a lot about agronomy because it's all about what's happening in the field, as well as understand chemistry and the whole realm of associated herbicides. And GM crops are also grown with pesticides, not only herbicides, because it's within the industrial agriculture realm. So I would say, and also the way that the risk assessment is not done by government. Risk assessment itself is done by the agrochemical company. It's then submitted with applications to government. Government does a desktop assessment against which it would have a set of guidelines that it will tick to see whether certain criteria have been met or not, and then would grant applications. I would say that if one just recalls what Ms. Swanby had testified, and she said that the registry of agrochemicals is kept by CropLife, and in order to access that you would have to so this also shows the lack of capacity of government to manage the database and manage its own registration system around agrochemicals, and then this unacceptable situation of conflict of interest, because how could an agrochemical industry hold and manage the registration database of agrochemicals in the country? So I would say that, I won't say that it's just blind rubber stamping, but I would say that we haven't had any success in our representations to government to consider re-registration of agrochemicals, and we haven't had any response to that application for more than 2 years. And we even wrote to the minister when he was appointed, Minister Steenhuisen, and we thought, well, maybe a fresh minister will be better and we will have more joy. Nothing. No response to our application for derogation. This is very, very unusual because we do not have a similar experience with the Department of Agriculture dealing with GMOs. We get very good responses from the registrar as well as from the executive committee who is in charge of decision making there. It's a very, very different situation. So I would say there's something that needs to be investigated in the office of the registrar dealing with agrochemicals under under Act 36 of 1947, in terms particularly of capacity in that office, if we do not even get a response for more than 2 years.
Thank you so much. I think that is very valuable in respect of the risk assessments. How
Dr.
is it
Carter,
verified?
Can I just pause here while we acknowledge that we are now losing our sign language practitioners who have to be excused at 5:30. Thank you so much for your presence today. I would like to then apologize to our stakeholders within the deaf community that they will be without assistance from now until the remainder of the evening, but tomorrow we will then ensure that they still have this support for tomorrow morning. Thank you so much. Dr. Carter, you may proceed.
Thank you, Commissioner. That was my perhaps last comment and submission. I do deem it very valuable that you were able to superimpose the concepts developed in the SCA judgment onto the current discourse. I recognize you also pointing out there may be a capacity concern at the registrar's office as well as the department's office, because you have tabled with us that not only have there not been any engagement on the substance of these concerns, but you have not even had a response. So certainly two things that we are going to follow up on. And then perhaps, commissioners, I just want to also table that this is the second time we have been referred to CropLife, bearing in mind that they are playing a quasi-governmental role in coordinating information that should be in the public, not only public interest, but in the public domain. I would like to implore the panel to consider inviting, in terms of our legislation, also them to respond to the allegations that have been tabled with the Commission under oath. Thank you very much, Commissioner, and that is all from my side. Over to you, Chairperson.
Commissioner Ntuli, any questions?
Thank you very much, colleagues, for your presentation. Perhaps just as a follow-up, are you able to clarify for those who might still be confused the three, or the relationship between these three, the Department of Agriculture, CropLife, and the registrar? If you could perhaps just assist us in understanding these three as well as their interface or interrelationship. That would be the first question.
As we understand the position, CropLife is a body that represents the interests of the agrochemical industry. They also exist internationally, but we do have a presence in South Africa. We routinely cross swords with them in international fora where we've known them for a long time because we were involved together with many other groups over the years trying to negotiate many international treaties, and they were very present in the negotiations of the Cartagena Protocol on biosafety, for example, in not wanting a protocol and not wanting the international regulation of genetically modified organisms. And they're also very present in other international fora dealing with pesticides, and our colleagues who attend those will be able to testify to that. I have to say that if you look at, just to come back to your question about the relationship between the Department of Agriculture and CropLife, what was very instructive to us was the Minister of Agriculture's responses immediately after the 5 children died of tuberphos poisoning in Naledi, Soweto. And it was almost a copy-paste, his position and that of CropLife, immediately blaming the spaza shops, blaming illegal imports from neighboring countries, all unsubstantiated. And in fact, the registrar of Act 36 of 1947 gave evidence to the Portfolio Committee on Agriculture that they in fact found manufacturers of tuberphos in the country. So the relationship between CropLife and the department is definitely something that needs further investigation. And the reason being that we are always shut down by the narrative that food security will be imperiled and people will starve in South Africa if we do not use pesticides. And the minister, there was a headline in the Cape Times, and it said, pesticides or tuberphos not being the banning not being in the offing anytime soon. It was just very clear, even before any investigation by Parliament was underway. So this stance by the Department of Agriculture to defend the use of agrochemicals, to defend CropLife, whereas he has and his department constitutional obligations, as we all know, also to protect human life and the environment, not only one industry. Of course, he has to take all economic interests into account. We understand that. But this unholy alliance, which became apparent when those children died, and the reaction of the minister was really very, very difficult for us to accept. And if it wasn't for Cabinet and the 3 jurors who presided over the tribunal that Heidi testified to, who themselves gave testimony to Parliament and the position taken independently by the South African Human Rights Commission on the issue, and the issue of pesticides that have nothing to do with us. This has to do with their own work and their own credibility and their own agency. We would not have had a cabinet decision to ban before. So I think that the registrar is a person we feel very sorry for, because the registrar has to be in the firing line, taking a lot of heat from all of us. But the registrar is just a government official, whereas the political
Maria?
responsibility lies further up. I'm sorry.
No, don't be
Commissioner.
sorry. I appreciate your response, but I'm just a little bit concerned about time, and I have 2 more questions which I will squeeze into.
Sorry, Commissioner.
Not a problem, Mariam. Thank you so much for your response. It has been helpful. It is a fact that our agricultural industry is heavily dependent on pesticide use, and therefore the agrochemical cooperations. You are equally correct to say the response from the ministry has often been that if you ban highly hazardous pesticides, then you are also then going to see a hike in food insecurity. What, from your experience and your research, would a just transition be from highly hazardous pesticides? If we were to ban all of the highly hazardous pesticides today, what does a transition, a realistic transition, look like? Given also the reality that many, if not the majority, of small-scale farmers also rely on pesticides for crop protection. So if we ban all of these HHPs today, what does the transition look like in realistic form? That would be my last question. Thank you so much.
A very difficult question, and I don't want to preempt a presentation that will be made tomorrow by a big coalition who made a submission on a just transition that we also made inputs into. But I don't think that we want to precipitate any kind of food security crisis in the country. We also understand that the industrial agriculture sector is caught in what we call a technological lock-in. The lock-in is deeply embedded and is not going to be an overnight transition out of. It's going to have to be phased. And I don't think we can talk about any phase out of industrial agriculture without the commercial farmers and the industry sitting at the table as well, to knock out what this transition would mean to a more socially just and ecologically sustainable alternative. The first thing is that they are locked into what, when I talk about a technological package, it's corporate seed, it's pesticides, it's inorganic fertilizer, and it's irrigation, credit. It's a whole bundle of issues, and the pesticide is part of this package. It can't be, it must be dealt with in a very comprehensive way. I think our colleagues tomorrow will come and talk about the mechanisms and steps towards a just transition. And I think that there's been a lot of evidence, and I think Dr. May, Julian May, also was asked the same question, and I think he also responded. We also will publish some work in the next couple of months detailing how successful other farming systems are that do not depend on the use of pesticides. And this is not just integrated pest management. It's also the application of the pull methodologies, many applications that find their home in the basket of agroecological practices. So the evidence is there, and I think it's going to have to be a phasing out of the use, particularly of highly hazardous pesticides and organophosphates in particular. I think that unfortunately, because of the confusion around the three submissions, we dealt in particular with the issue of where would the resources come from, the resource mobilization issues. And we highlighted in particular harmful subsidies. So our government subsidizes the agrochemical industry. There's a lot of tax breaks being given to support industrial agriculture. So the whole issue around harmful subsidies would have to be part of the discussion, and how some of this money and finances can be redirected to supporting a just transition. So that would be my short answer,
Thank you,
Commissioner.
Thank you so much, Miriam. And then just to emphasize also for the record that we have received all three submissions, but we have received an overwhelming number of submissions overall for this inquiry. And we have not invited everyone who has made written submissions, but we have sampled based on the submissions and also based on the thematic areas that we are focusing on. So even though we have today focused on one of these submissions, which is on pesticides, we can assure you that all three of them are being considered as part of this investigation. So thank you. Over to you, Chair.
Thank you, Commissioner Nduli. Commissioner Kwinana?
Mine is just one, Chair. I know that you don't want me to ask all my questions. Is it possible for you to provide us those correspondences that were sent to the minister that were not responded to? If same can just be provided, Madam Chair. Thank you so much.
With pleasure, we'll send you the correspondence to both the we'll send you the submissions, the correspondence to the registrar, as well as the letters to the minister, and we'll do that within the next couple of days. Thank you, and we would like to thank you very much for giving us this opportunity to be with you today. We appreciate you must have received overwhelming submissions. The food system is extremely important, and it has so many dimensions, and we very much appreciate this opportunity. Thank you very much. And also your assurance that all three will be taken into account. And we wish you well with your onward work, and we will be sure to send you that correspondence in the next couple of days. Thank you very, very much indeed. And good luck with your work.
Thank you so much. I had several questions, and because of time constraints, I'm going to ask and propose this. The additional questions from the panel and evidence leaders will be forwarded to you in writing, and then you have an opportunity to respond. Thank you so much for availing yourself to make presentations, but also thank you for waiting until such a late hour of the day to make presentations. We acknowledge that. Thank you so much. You are now officially off the podium. We would then like to call our last stakeholder to the podium, who will then be making representations. This is the Minister of Forestry, Fisheries and the Environment. Thank you so much. I see that there's a whole entire team of about 9 people. DG purposes, I'll ask you to lead the process, but perhaps before we do that, in terms of the procedure, can you just perhaps put it on record the absence of the minister and the reasons? Okay, thank you so much. Perhaps let's start with the introductions, and then we'll start with the procedural questions in respect of the presence of the ministers, but we'll do that under oath. I will allow you to introduce yourself and then hand over to your colleagues who will then introduce themselves, and we'll start with the procedural aspect.
Thank you very much, Commissioners, and thank you for the opportunity you have given the department to come and present on the submissions that we've made in writing. I do want to table once again Minister's apology because of a commitment that he could not be able to excuse himself from. I therefore am here as the Director General of the department, and the colleagues that are with me are basically the DDG's Deputy Director Generals that are responsible for the areas that the Commission is interested in as far as the what the investigation is on. My name is Nomfundo Chabalala. I am the Director General of the Department of Forestry, Fisheries, and the Environment. I will then pass on the mic to my colleagues. Thank you.
Good afternoon, Commissioners, everyone present. My name is Vanessa Benderman. I'm the Deputy Director General, responsible for regulatory compliance and sector monitoring.
Good afternoon, Commissioners. My name is Phumeza Nodada. I am the Deputy Director General responsible for forestry management.
Good afternoon, Commissioners. I'm Advocate Farhana Patel. I am the Chief Director responsible for appeals.
Good afternoon, Commissioners. My name is Maisela Kekana. I'm the Deputy Director for Climate Change and Air Quality Management.
Good afternoon. My name is Tlaura Maru. I'm the Chief Director responsible for climate change adaptation.
Good afternoon, everyone. My name is Motlhago Flora Mogotlo. I'm the Head of Branch for Biodiversity and Conservation.
Good afternoon, Commissioners. My name is Molebatsi Mola. I'm the Chief Director responsible for corporate legal support and litigation. Thank you.
Afternoon, it's again, Commissioners. Surprise Zwane, responsible for chemicals and waste economy program coordination in the department. Thank you.
Good afternoon, Commissioners. My name is Sasa Pierha. I'm the acting DDG for fisheries management. Thank you.
Thank you very much, Commissioners. That's the team that is here before you. Thank you.
May I just ask, will all the respective individuals from the department represented be all making presentations and answering questions?
So I'm going to do the presentation in totality. But if then there are questions on the details, be it fisheries management, climate, the respective Deputy Director General will then be in a position to provide the Commission with all the details required. But I'm making the presentation.
Thank you so much. I'm going to ask if we can start swearing in. We'll start with yourself, and then we'll move to the other colleagues, and then we'll start with the procedural aspects of this part. I know the evidence leaders are waiting for that part. Full names for the record, as well as, full names for the record.
My name is Nomfundo Clementine Chabalala.
Will you be taking the prescribed oath or affirmation?
Prescribed oath.
Do you consider the oath to be binding on your conscience?
I do.
Do you say that the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you so much. Can we perhaps ask the colleagues when they're taking the prescribed oath or affirmation if they can just be at the table? It makes it easier. And then you'll go back to your seats.
I'll take the oath.
Full
but
names
I'm-
for the record.
I'm going to use my official name, which is Devanagi Benderman.
All right. Are you going to be taking the prescribed oath or affirmation?
The oath is fine.
Do you consider the oath to be binding on your conscience?
I do.
Do you say that the evidence you're about to present before the commission is the truth, nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you. Full names for the record.
Pumeza Nwabisa Nodada.
Ma'am, will you be taking the prescribed oath or affirmation?
Oath.
Do you consider the oath to be binding on your conscience?
I do.
Do you say that the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Farhana Patel,
Will you be taking the prescribed oath or affirmation?
prescribed oath.
Do you consider the oath to be binding on your conscience?
I do.
Do you say that the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Myself Kekana,
So will you be taking the prescribed oath or affirmation?
affirmation.
Do you consider the affirmation to be binding on your conscience?
I do.
Do you affirm that the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, "I affirm."
I affirm.
Thank you.
Go Emmanuel Ramaru,
So will you be taking the prescribed oath or affirmation?
an oath.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you say that the evidence you're about to present before the commission is the truth, nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Motlhago Flora Mogotlo,
Ma'am, will you be taking the prescribed oath or affirmation?
an oath.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you consider the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, "So help me God."
Yes, I do. So help me God.
Thank you.
Molebatsi Mary Jane Mola,
Will you be taking the prescribed oath or affirmation, ma'am?
prescribed oath.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you say that the evidence you're about to give before the commission is the truth, nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Surprise Begitemba Zwane,
So will you be taking the oath or the affirmation?
the oath.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you say that the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Sasa Pierha,
So will you be taking the prescribed oath or affirmation?
prescribed oath.
Do you consider the oath to be binding on your conscience?
I do.
Do you swear that the evidence you're about to present before the commission is the truth, nothing but the whole truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you so much. DG, in terms of the procedure, it was 1, the absence of the minister and the deputy minister; 2, whether the minister has given you the necessary authority to present him, and whether he confirms that the statements that will be made by yourself as well as the colleagues from the department, he binds himself with and will be held accountable for what is stated today.
Yes, I would want to, Chairperson and Commissioners, confirm that I have been mandated by the Minister, given that he was not able to attend. And indeed, the statements which we are going to be presenting and providing details on is binding to the Minister. Thank you.
Thank you so much, Commissioner Kunana. Any questions?
Thank you, Chair. Is there a written confirmation of that mandate?
We do not have a written confirmation, Commissioners.
And with regard to the minister's whereabouts, what is the information regarding same?
He has a critical meeting in Cape Town. I think it's one of the stakeholders, Commissioner. I think it's a meeting with the stakeholders.
TG, you need more than that. We are a Chapter 9 institution that needs to be respected when a minister is subpoenaed to appear before the commission. So the fact that it's a stakeholder engagement is not enough, especially because it looks like you're just saying it. There's nothing concrete that you are presenting before the commission. Are you able to source same before we can proceed?
I can try and give him a call and request the office. My understanding is that the office has been liaising with the commission in terms of him not being able to attend, but I can't be in a position to locate him.
Thank you, Chair.
Thank you, Commissioner Ntuli. Evidence leaders, any questions regarding the procedural aspect?
Sorry, I was looking at something I was caught unaware. Maybe for us is to clarify, because Chair, we've heard from Commissioner Kwinana that the minister was subpoenaed. If that can be confirmed, because of course, if he's under subpoena, we do not believe that, particularly in the absence of that delegation of authority, it's not just delegation in the sense that you appear on my behalf, delegation of the ministerial powers, because if the minister is subpoenaed, whoever is here must have the full delegated authority of being a minister. If we can just get that clarification, I'm not sure even legally that is possible, but that is the implications, that whoever is here is a minister. Maybe we can get that clarity, and then we can make further proposals once that has been clarified. Thank you.
May I just ask, I see that Kenneth is still here. Kenneth, was the minister subpoenaed or was he sent an invite? Oh, Ephraim, oh there, I see Ephraim is there. Oh, can we just perhaps have you come down and then put it on record that this is the process that was undertaken with this particular minister? Ms. Mulombo, we had deliberations and it appears that the minister was invited and not subpoenaed, but this is before the subpoena notice was sent out. Oh yes, please, Dr. Carter, please share the information so that we are all on page regarding the legal service unit's submissions. Thank you.
Thank you so much, Chairperson. We have discussed it with the legal service unit as well as the inquiry coordination team. It appears that the minister was invited to attend the proceedings. It subsequently appeared that he was not available and that the deputy minister was delegated, who then also indicated unavailability to our legal services unit. Both of these were invites and not subpoenas, because these invites were in fact sent with the assumption that the political office bearers would in fact provide the cooperation and appear in person. However, that was then not the case, and it was delegated to the DG, who is here with us today. Our submission then, Chairperson and Commissioners, would be that we do get the delegation in writing, that be tabled before the Chairperson in order to allow us to proceed. There is, as we speak currently, no subpoena that has been issued against the Minister or the Deputy Minister. And then secondly, that the reasons, I do not deem that the reasons have been properly tabled with the Commission as to why the Minister himself is unable to attend the Chapter 9 institutions inquiry, national inquiry. So perhaps we can then just request the panel through you to table and assist and request the department to table those submissions as well. Just to check in with my fellow colleague, Ms. Mlobo. You covered any? Oh, we covered. Chairperson, over to you.
Thank you so much. The panel has deliberated, and our decision is that we would need a written delegation of authority from the minister. At this moment, we will adjourn, and then once you have any communication, you'd advise us. We'll adjourn until we're able to have a way forward regarding that written confirmation of delegation of authority. Thank you. We will adjourn. Thank you, colleagues. Thank you so much, colleagues. We are going to adjourn this evening. However, the department is still on the podium. We will finalize the issues on the minister's availability as well as physical presence before the inquiry tomorrow morning. So the department's officials that have been sworn in are warned to appear tomorrow morning before the commission at 8:30. Because it's a warning, you're permitted to then attend virtually. Thank you so much.
Thank you very much, commissioners, for your indulgence. Indeed, we are going to be connecting line, and I think the minister will before he goes into a meeting for him to be available online so that we can then sort out the issues of him being present here physically. Thank you.
Thank you so much. Colleagues, that adjourns the first day of the inquiry. Sorry, the third day of the inquiry, the first day of the week. Thank you so much. I'm going to then we'll see you tomorrow at 8:30. Tomorrow we're starting at 8:30, colleagues.
Commissioners, can I request that we be given the link for the meeting tonight so that we sort ourselves? We don't want to have some hiccup